or whatever. Go to one memo.
Two fresh admission.
No, only one. All right. D'accord.
Supplementary list item number 1, fresh admission.
Madam, filed an application under section 24 of this CPC. CPC for
Further to Noyagod, why? Further to Noyagod, why?
the petitioner is a lady.
So,
The petitioner is a lady staying separately from her husband since long, now residing in her parental
no, but this is not a matrimonial, this is a civil suit. No, matrimonial suit. Matrimonial case.
civil suit.
Oh, so civil suit, why? So you are not required to attend the court every day.
Lord, it's a lady with it's a long distance cover.
Long distance kahin cover kariye?
Life risk se hajur achhi.
Live long distance kahin ki cover kariye civil suit re? मत कौन? Civil suit रे कौन daily affair करिया दरकार था करो?
My lord, that तो it's a lady तार रोजगार नहीं. से
नहीं आपने मो क्वेश्चन आंसर दो ना देंगे. मो क्वेश्चन है simple. If it is a civil suit, the party she is the plaintiff or the defendant.
The defendant.
She is the defendant. So she is not required to attend the court physically every day.
Lord, the monetary problem is there.
ମୁଁ ପୁରା କହୁଛି ସେ appear କରିବା ଦରକାର ନାହିଁ. ଯଦି appear କରିବା ଦରକାର ନାହିଁ କାହିଁକି transfer ହବ?
Quality के सेठी ठीक है ना.
नहीं. No. You are not answering my question. Repeatedly I am asking you, sir. You are not answering my question. Why I am again asking you, sir, what is the necessity? She is not required to attend the court every day physically. This being a civil suit. So, why should it be transferred?
The monetary problem is there.
The petitioner, who is the defendant in CS number 305 of 2022, pending in the court of learned senior civil judge Khorda, seeks transfer of the said case to the court of learned senior civil judge Oroga on the ground that she, being a lady, has financial problems for which it would be difficult on her part to appear before the said court on the dates of posting of the case. So this court observes that the case being a civil suit, the petitioner, being the defendant, is not required to physically present before the court on each date of posting of the case. As such, I don't find any valid reason to transfer the proceeding. Stop the transfer application is therefore dismissed. Yes.
Item number 2.
Item 2.
Petitioner is the wife, my lord. Transfer of divorce case from Kendujhar to Rourkela, my lord.
All right,
Please
take
reject-
notice. Issue notice. Stay. Who ye? 25th October.
Yes, my lord. I filed for stay.
Item number 3.
May it please your lordship. Similar transfer petition, wife is the petitioner, seeks for transfer of the matrimonial suit from Jharsuguda to Sambalpur. She is now staying with the parents in
What
Sambalpur.
is this writ appeal?
That one earlier I had come, the wife had come for transfer of this petition. It was rejected and it was also rejected in writ appeal. Now, my
Writ
lord,
appeal lies against this rejection.
anyway, my lord, it was filed then. To 2022, it was there.
Release this matter tomorrow along with TRPC number 454 of 2022 and WA number 436 of 2022. Yes.
Yeah, Monday.
It will come tomorrow. It will come tomorrow.
Item number 4.
Wife has filed a CP, my lord, a transfer petition, my lord. But the CP number 85 of 21 is pending before the Hon'Ble, the family judge Hon'Ble, my lord. So she seeks transfer from family judge Hon'Ble to Sambalpur, my lord.
All right. Take notice.
My lord. I is also there.
Who you have filed another IE for addition of parties?
It was, my lord, I have addition party of, there also lordship had granted opposite party note 2. So opposite party note 2 notice is not required, my lord.
Opposite party notice number not required.
Not, my lord. Because the husband has given an allegation that I have a
Issue
relation.
notice to the opposite party number 1 for the time being by speed post, fixing a short returnable date requisites be filed within 3 working days by tomorrow. Requisites be filed by tomorrow. List this matter on 25th October. Huh? Stay, published.
Item number 5,
But in this case, my lord, though I know that your lordship is not in favor of transferring the case from Cuttack to Bhubaneswar or Bhubaneswar to Cuttack. Knowing that, my lord, I have filed this application on the ground that marriage is.
Knowing that it will be rejected.
No, no, no.
Okay.
ଆପଣ ଶୁଣିଲେ କହିବେ ଯେ
ନା ମୁଁ ଶୁଣିବି ଆଉ କାଇଁ
ନା
ଆଉ ଶୁଣିବି କାଇଁ ଶୁଣିଲେ କାଳେ ଯେ ଇଏ କରି ଚେଞ୍ଜ କରିବ
ଆଜ୍ଞା, ଶୁଣିଲେ କାହିଁକି ନା ଇଣ୍ଟେନସନ ଟା କହୁଛି
କୁହନ୍ତୁ
they are married ମାନେ love married for 8 years they live together due to some dispute my lord the husband has filed this application I have filed this application ସେଠି ଧରା ଦଉନି I have filed this application notice ଗଲେ ଆସି କଣ ଆପଣଙ୍କର permanent conciliation mediation center କୁ ଗଲେ matter could be
ଶୁଣନ୍ତୁ
ହେଇଯିବ
ଆପଣଙ୍କ ସବୁ କ୍ଲାଏଣ୍ଟ ବଡ ବଡ କ୍ଲାଏଣ୍ଟ ଆଜ୍ଞା ଆମେ କ୍ଲାଏଣ୍ଟ କୁ ଦେଖିଲା ବେଳକୁ ଡର ଲାଗୁଛି ବର୍ତ୍ତମାନ
କଣ କରିବି
ମୁଁ ମତେ ବେଶୀ ଡର ଲାଗୁଛି କଣ କରିବ
କହୁଛି
ନାଇଁ ନିଜର କେସ୍ ତ ନୁହେଁ
ନିଜର କେସ୍ ଆଜ୍ଞା
ଛାଡ଼ ମୁଁ ଆଉ ସେ ବିଷୟରେ କିଛି କହିବିନି
ଆଜ୍ଞା
କଣ କହିବି
ଏବଂ ଝିଅଟା ଏବଂ desperate to join with her husband.
All right, issue notice to the opposite party by special messenger, the cost of which shall be assessed and deposit be made by tomorrow. List this matter.
ମଣ୍ଡେ ଯାଏ ରଖନ୍ତୁ କାରଣ ସେମାନେ ଆସେସ୍ କରିକି ମୁଁ ଦେଲା ବେଳକୁ ଡେରି ହେଇଯିବ
କାଲି ଶନିବାର ଅଛି ନା କୋର୍ଟ ଅଛି
ଆଜ୍ଞା
କାଲି କୋର୍ଟ ଅଛି ବୋଲି ସେଥିପାଇଁ
ମାନେ ଆସେସ୍ କରିଦେଲେ ମୁଁ ଦେଇଦେବି
ଆସେସ୍ ଇଟ୍ will be done. First hour ଅଛି ପଳେଇବ ସାଙ୍ଗେ ସାଙ୍ଗେ. List this matter on 6th September. Huh. Yes.
item number 6,
That's all.
item number 7,
Item number 7, my lords, may I please. My lords, this is a matter arising out of the disengagement of service of the petitioner who was
Disengagement of
disengagement of service, my lords,
service. Yes.
of the petitioner who was working as an Anganwadi worker, my
Yes.
lords, and the subsequent order in passed in appeal, my lords.
Yes.
My lords, if your lordships may kindly see the order passed in appeal in annexure 11, starting from page 46, my lords.
Yes.
My lords, the crux of the matter before your lordship is,
Sir, come to page 46.
my lords,
It is page 2 of the order. Where is page 1?
no, my lords, actually the your lordships had directed, there was a problem in the pagination. I had corrected it in the copy, my lords.
नहीं correction है ही नहीं देख लो निकला
Your lordships had directed by order dated 5/8. I had complied with the direction.
no pagination of annexure 4
Annexure 11, my lords.
but the order reflects annexure अच्छा annexure
Subsequently, your
11 yes yes
lordships have
annexure 11 से कहीं से किसी ही नहीं देख लो Annexure 11 it starts with page 2
my lords.
at page 46
My lords.
where is the first page the constitutive page
Actually, the first page originally was at page 49 due to pagination
49.
error, my lords. But that has been corrected.
that is not there कौन सी टेची
It's not to the page. It's not to the page.
बट 9 ଅଛି ଏଠି ତ ନାହିଁ ସେ ନାହିଁ ମଧ୍ୟ ଫିଜିକାଲ ଫାଇଲ୍ ଏବେ I very much doubt whether this is Cost title kahin? The appeal to cost title kahin? There is no cost title of this appeal.
No, my lord.
Simply starts with the order.
My lord.
So you have not obtained that probably. Anyway,
My
what is
lord.
your case?
This, I obtained the certified copy, my lord.
Where is the certificate copy?
My lord.
You have filed it?
No, my lord.
You have not filed it?
No.
Yes, what is the?
My lords, the crux of the matter is, my lords, I was working as an Anganwadi worker. My pay from the month of November 2018 to May 2019 was not given to me, for which I approached the CDPO. I submitted my representation that my pay may be released. But the CDPO demanded a bribe of 10,000 rupees to release my remuneration, my lords. Subsequently, since this matter got highlighted and newspapers picked it up and it blowed out of proportion, my lords. They just to act vindictive towards me, my lords. They submitted. They gave me a show cause. The first show cause was on, my lords, 17/12/2020. Much later to the occurrence. They in the year 2020 they gave me. My pay was not given to me from November 18 to May 19. My lords, thereafter I have received my remuneration. No show cause was given to me, but fictitiously in December 2020, just to portray their vindictive attitude towards me, my lords, they say that you were derelicting in your duty towards as the Anganwadi worker, and they served me a show cause, and thereafter, my lords, they dismissed me from service.
What is your reply to the allegation that
lords,
you remain unauthorized absent and the
my lords,
AWC was also?
It's clearly an after.
No, wait. Here, when the court is speaking, why are you interrupting?
I'm sorry, my lord.
What is your explanation to the allegation?
My lords, I respectfully submit that the allegation is clearly an afterthought, my lords.
So how can this court find out? The allegation was inquired into and found to be correct, and you have been proceeded against.
My lords, may
Action has
kindly,
been taken. So how can this court make a roving inquiry now? A writ court. What is wrong in this order? You have to point out what is wrong in this order.
my lord.
The quasi judicial authority has passed an order, and we are in a subsidiary jurisdiction. Our scope of interference is very, very limited. Tell me, show me some palpable illegality so that I can interfere.
My lords, may kindly see page 18 of my writ petition.
Page 18.
It is a newspaper clipping of a leading newspaper Prameya, dated 14/5/2020.
So
My lords, on the left hand side paragraph, third line from the last, my lords. May I read with your lordship's
no,
permission?
you don't have to read because the newspaper clipping has got no meaning.
My lord.
You are challenging not the newspaper, but you are challenging the
My lords,
the order. You have to show on the face of it how it is wrong, how the order is wrong.
my respectful submission before your lordship says, my lords, when this matter was first inquired into, I had submitted the MIS register, my attendance register, and all the necessary documents.
Place the order. Place the entire order. Let us see. On the basis of appeal petition.
The order starts from page 46, my lords, which is at
During hearing of the case, the advocate for the appellant submitted that the appellant was working.
May I read, my lord?
Just. No, yes. During personal hearing of the sub-collector Jharsuguda, the appellant stated nothing except that she will do her duty properly henceforth and left the office. It almost amounts to admission of these charges.
My lords, but these authorities are quasi-judicial and they are my supervising authority, my lords. CDPO and the sub-collector are supervising of authorities. I have submitted my ground. So the Anganwadi worker is, my lords, not a very highly educated person. She stated all her grounds before the sub-collector, but the same has not been taken note of in the order sheet, my lords.
Where is the show cause issued against you? Where is the show cause?
My lords, 5 series, my lords, may kindly see.
5 series.
And this is the only show cause I have received, my lords. I have taken that averment. Page 27, to which I filed a reply.
Just ଆପଣ ଲେଖିଲେ ଘରର ବିଭିନ୍ନ ପରିସ୍ଥିତିର ଅସୁସ୍ଥ ହେବା ଦ୍ୱାରା ମୁଁ 25 ନାଇଁ 27 କଣ 21 28/5 ଏବଂ 11/6 କିଛି ସମୟ ପାଇଁ କାର୍ଯ୍ୟର ଅବହେଳା ହୋଇଯାଇଥିଲା, ଯାହା ପାଇଁ ମୁଁ ଘୋର ଦୁଃଖିତ। ମୋର 3ଟି ଛୋଟ ଛୋଟ ପିଲା ଅଛନ୍ତି, ତେଣୁ ଏହାକୁ ଦୃଷ୍ଟିରେ ରଖି ମୋର ଏ ଅବହେଳା ଏଇଥର ପାଇଁ କ୍ଷମା କରି ଦିଆଯାଉ ଏବଂ ଏହାପରେ ମୋର କାର୍ଯ୍ୟର କୌଣସି ପ୍ରକାର ଅବହେଳା କରିବି ନାହିଁ। So there is an admission, madam. At least a part admission, madam. Yes, state.
Copy is not opening.
Copy has not been given. Yes, the show cause does not really simply says that ଆପଣଙ୍କୁ ଆପଣ ଅନବରତ ଭାବରେ ସରକାରୀ କାର୍ଯ୍ୟର ଅବହେଳା କରି ଆସୁଛନ୍ତି. This is completely vague.
Yes.
କଣ ଅବହେଳା କରୁଛନ୍ତି କଣ ନା କିଛି ସ୍ପେସିଫିକ ଦିଆଗଲା, କିନ୍ତୁ ଯୋଉ ଡିସଏନଗେଜମେଣ୍ଟ ଅର୍ଡରରେ 1 2 3 4 6ଟା ଦିଆଗଲା ଯେ ଆପଣ ଏହା କରିଛନ୍ତି, ଆପଣ ସେୟା କରିଛନ୍ତି, ଏହା କରିଛନ୍ତି ଇତ୍ୟାଦି. Which was never asked. She was never asked to show cause on these points.
Yes.
She was asked to show cause on different, on other some other points,
Yes.
and she has been proceeded against or disengaged on entirely different points. Yes. Learned, sir, your good name, I'm forgetting.
Sasanka Shekhar Patra.
Sri S.S. Patra. You are the AGA.
Yes.
Sri Sashikanta Shekhar Patra, learned ASC. You have been allotted to this court
Yes.
today.
Today.
Only for today.
Perhaps.
Mr. Patnaik, some personal difficulties, so today
What about Mr. Yardas?
he will be there. Another copy.
No, not that I have any objection. Sri S.S. Patra, learned ASC, accepts notice on behalf of all the opposite parties. You have not prepared your case at all. For all the opposite parties. Nowadays, copies are not being required to be given.
LMS.
LMS ରେ ମିଳୁଛି ତ
Today I could not find from LMS, for that only I am asking.
All right, you give a copy. Let an extra copy of the writ application be served upon Sri Patra in course of the day. Place this matter. No, let a counter affidavit be filed answering the contentions raised in the writ application. So further, the state should clarify as to how, as to the basis of as to clarify as to when the show cause notice did not mention the specific allegations. How could the petitioner be disengaged on the grounds cited in the disengagement letter, in the order of disengagement? Let's this matter on 27th September. Yes.
See, free copy of order.
Yes, yes.
Free copy of order.
Free copy of this order be handed over to see the State Council for compliance. Yes. PL कौन लिखा है जी? Okay, कर ले अच्छा. Oh.
Item number 8.
May I plead them? Allot the order at annexure 19, page 58 is the impugned order by virtue of which the collector has directed for disengagement of the petitioner as Shiksha Sahayak. My lord, in the year 2014, the petitioner joined in service, and 2016 he was transferred to another school. He joined there, and due to suffering, I given the medical document, all the medical document I have given. He remained absent for some time with the permission of the headmaster. After recovery, when he joined in the service, he was not allowed to join. Thereafter, he ventilated his grievance before the higher authorities. That was not considered. And he approached this honorable court in the earlier writ petition. The Lords will get at page 12. And the direction was there to the collector to consider his case. Thereafter, my lord, they slept about the matter and he filed the contempt. After that, the matter was taken up. And the collector passed the order, your lords will get at annexure 18, 18.
Yes.
At page 57. As such, the employment status of Sri Sethi does not appear to be disengaged. With the aforesaid background, it is ordered that the DO come, Sobhanpur shall take a decision in the matter following due process of law.
Yes.
And his case was also not considered. And for 6 months, DO sat over the matter. Thereafter, the petition again approached this honorable court. After coming to know that the petition has approached this honorable court, now the collector, your lordship, has passed the impugned order saying that the petitioner is to be dismissed by 58.
That is one thing, and there is a retrospective termination. But what is your their allegation is that you are unauthorizedly absent from 17/7/2026 till date.
No, that is not correct.
No, that is their allegation.
That allegation is, but my lord, your lordship have a glance annexure 3, annexure 5, 6 and 7. This is my consistent representation to the authorities seeking for a direction to the headmaster to allow me to join in service. My sole grievance was that the headmaster is not allowing me to join in my service.
So annexure to page 20.
ଏସବୁ ଦ୍ୱାରା ଆପଣଙ୍କୁ ଜଣାଇ ଦିଆଯାଉଛି ଯେ 6:30 ଘଟିକାରେ ଆମ୍ବେ ସେଗଡ଼ା ହାଇସ୍କୁଲ ସେରଗଡ଼ା ହାଇସ୍କୁଲ ବିଦ୍ୟାଳୟରେ ଯୋଗଦାନ କରିଥିଲେ।
Also to that, I submitted the repentant reply and all the documents your lordship have a glance 10 series, annexure 10 series medical document. Those documents have never taken into consideration. And I was not allowed to join. That is why I also approached this honorable court in 2 occasions. Content filed. Thereafter, my case was taken up.
After this 2016 only annexure 3, 2018 only he
Yes,
contacted. Yes.
repeated representations. You just take instructions. I'm not inclined to
Yes.
admit this application. I mean, admit means a difficult case. You take just instructions. That he claims to have submitted repeated representations, and some of his representations, including the medical certificates, appear to have been also forwarded. And the John Director has called upon the headmaster to reply. I found a particular.
Yes, sir. Yes, sir.
Yeah, isn't it?
There. It is reflected in.
But probably nothing has been done. You see, come to page 22, annexure 4. The district project coordinator has asked, with reference to the subject, you are directed to submit the leave details along with submitted leave applications, medical certificate. So what action was taken on this? This has to be clarified.
Yes, sir.
You take instruction. Then State Council will take instructions with regard to the amendments made in the unit application. And in particular, clarify as to what action, as to what step was taken by the headmaster of the school pursuant to the letter dated 17/1/2018 of the DPC Subarnapur. Bracket annexure 4. List this matter
28th September.
20th September.
3 copy orders.
Yes,
3 copy of order.
3 copies will be handed over. To the State
28th
Council.
September.
20th September. Yes.
Item number 9.
My grievance is, in spite of the order under annexure 9, the order passed by the additional district magistrate Baleshwar, the opposite party number 3 and 4 have not taken any action till date, even if the order was passed on 6th December 2014. And at page 31, it is held that proper inquiry about the residential status of the appellant and respondent number 3 has not been taken up prior to the selection of Anganwadi worker in respect of Dubukasai Mini Anganwadi Center.
No,
And
Mr.
yes,
Mahathi.
it's-
No. He doesn't have any power to remedy the matter. He is a quasi-judicial authority. How can he remit the matter to the selection committee to do the? He has to either answer it or reject it. Either allow the appeal or reject the appeal. He can't delegate it to any other authority. That is the settled position of law.
It is found on from the report of the CDPO that the opposite party number 5 is not belongs to the
Anyway,
Anganwadi Center area.
then he should have passed appropriate order. He cannot delegate it. He cannot delegate the power to somebody else. That is the settled position of law. There is a decision of this court also, division bench.
For that reason only that he said that
He cannot. He does not have that power. He does not have that power. He is a quasi-judicial authority. He has no power to delegate it. Yeah, that was passed by this court in the case of education, presiding officer education tribunal, who is a senior district judge. He remanded the matter to the director for disposal. This court completely deprecated that order, said that you have no authority. A quasi-judicial authority has no power to transmit it to, delegate the power to somebody else. Whatever was there, you decided. Either way, so that you get a chance to challenge that order if it goes against you.
yes.
I think what is the decision, Mr. Mahapatra? Jaspal, kaun sir? Jaspal na kaun? Jasjit Kaur na something like that. Harjit Kaur decision. Direct decision on the point.
Then there is no remedy to
Kim the remedy upon you have rightly approached this court. This order will be set aside, but the direction will be to the ADM to hear it on merit, not to redelegate it.
yes, that order will be.
I will pass that order. If you want, you can see the Harjit Kaur decision. Let it come tomorrow. I'll pass that order tomorrow. Go through it.
Monday.
Thank you. Kali aswe to
Kali ba achuti?
ki कहला तुझे? इतना छुट्टी नहीं लाओ.
Monday.
Monday. Monday ना सीधा आसो आरो शुक्रवार. ଆର ସବୁ କାଲି ଆସୁ କଣ
କାଲି ଆସୁ
List this matter tomorrow. You examine that decision.
ଆଜ୍ଞା ଆଜ୍ଞା
But offhand, it strikes to my mind that the quasi, I think that is the ratio laid down. Yes, Mr. Sharma? Right. Quasi judicial authority has no power to delegate the
Limit
power.
back the
You cannot. You have decided. You may decide whatever you want. On merit, whatever. You say that there was a report saying that opposite party number 5 does not belong to the service area.
yes.
He should have conducted that inquiry and arrived at a particular finding.
In the report of the CDPO, it is clear that she is not belongs to.
Yes, yes. As a proper inquiry ହେଇନି ତମେ ଆଉଥରେ ଶୁଣ ସେ ହବ
ସିଏ ତାଙ୍କର ସୋ ମୋଟ ପଠେଇଲେ କହିଲେ ସେ ଆଉଥରେ ଏନକ୍ୱାରି
କରିପାରିବେନି ସେ କରିପାରିବେନି ସେ ପାୱାର ନାହିଁ ଆଉ ସମୟ ହାଇକୋର୍ଟ ହେଇଗଲା ହବ କି
କାଲି ଆଣିବି
List this matter tomorrow. You just ask Mr. Sharma, he'll give you that.
ଆଜ୍ଞା
Harjit Kaur versus so and so.
Item
Yes.
10.
Not, I'm challenging the appointment of opposite party number as the Anganwadi worker. My representation pending before the ADM Balangir under annexure 5.
No, no, what happened? What happened?
But irregularity is that two different date of birth has been the school.
No, there was an advertisement.
There
You were an applicant.
I have applied and the opposite party number 5 also applied.
Yes.
And appointment has been given to her under annexure 3. But two different date of birth mentioned in the school authority has giving a date of birth according to their register and
So file an appeal.
I have submitted annexure 5 is pending before.
The representation will be treated as an appeal. When was the opposite party number 5 selected?
2022, I have submitted the appeal 2022.
2022. Then it will be under the old guidelines.
Right.
All right.
Annexure 5.
The petitioner is aggrieved by selection of opposite party number 5 as Anganwadi worker of କୋଉ ଜାଗା?
Sir,
ଗଡ଼ କଣ? ଗଡ଼ ବାହାଲ।
God Bahal.
ଗଡ଼ ବାହାଲ କ Anganwadi center. On the ground that there is discrepancy with regard to her date of birth, which was apparently ignored by the selection committee.
Madam.
As such, her selection was not, her candidature was not considered. Highlighting her grievance, the petitioner has submitted a representation addressed to the ADM Balangir on 25/2/2022, which is said to be pending. Stop. Since the guidelines provide the remedy of appeal against order of selection to the ADM, the writ application is disposed of, directing the ADM Balangir to treat the representation of the petitioner as an appeal and to dispose of the same in accordance with law within a period of 2 months.
Item 11.
11.
This is a peculiar case in the sense the third round before your lordship. Third round one, I have already lost in the read petition. Thereafter, the read appeal has also been lost. Then, by virtue of another decision rendered by your lordship, the hope has been rekindled in the petitioner. Therefore, he has approved me. And if he can be helped, my lord, only by way of the application of principle of restitution, they do with this.
What is the law in this regard, Mr. Purohit? What is the law in this regard? I think law is heavily stacked against you. Since you have approached and you have lost. Now, if somebody else wins the, I don't know. What is my judgment?
Your lordship judgment is
Judgment page 51.
Ramesh Chandra Swain. I have given the copy, Annexure 11, page 51. That is in respect of the requirement of OTT in the appointment of SS. Your lordship has also passed the same judgment. A past judgment was passed by
Division bench.
Honorable Justice Sanjeev Panda.
That was a division bench judgment.
No, no. All the judgments are single bench.
So
single bench judgment. Thereafter, in my case, the sole difficulty was in the first petition. that came up before the honorable judge during the COVID period. The advocate for the petitioner could not remain present. And the basing on the counter, the case was decided that OTT is required. Therefore, I having not got that qualification, the case was rejected. Whereas by that time, Justice Sanjeev Panda had already delivered the judgment that OTT is not required.
No, not required. A person cannot be debarred only on the ground of not
Exactly, my lord.
he can be engaged,
Not the required
engaged and can be given liberty to complete OTT.
after getting the.
That is what I have also.
My lord, your lordship has also passed the same
given.
judgment.
Your lordship also that's.
And other judgments also of this honorable court, there are many say. In all
But
such,
will res judicata not stare at you?
then came, I appeared before the judicata in this case, my lord. In respect of double the petition, the views are different in this honorable court.
Please find out those judgments.
One is, my lord, one is given by Justice Sinha. And that one can ask for the enforcement of the judgment passed in the earlier case, that is seconded. And the second judgment has been rendered by Justice V.P. Satpathy. He has said that the second writ petition is not maintainable if at all one.
You can do one thing, Mr. Purohit.
My lord.
In view of the pronouncement, in view of this judicial pronouncement,
My lord.
which obviously may not have been taken note of by the authorities,
My lord.
we can grant you liberty to move the authorities again so that you may get a fresh cause of action. Even if they reject it, you can come to the court. Right now, directly, this court may not be able to issue a mandamus because the res judicata will
My lord.
be there.
My lord.
But if you can seek withdrawal, simply withdrawal with liberty to apprise the authorities in light of this judgment, then they may take a decision. Either way, they'll take a decision.
I will request your lordship to pass a judgment on merit of the case. Even if it is dismissed, my lord, I will have a cause of action.
No, but what will happen is now I want to give you a cause of action.
My lord.
Instead of getting into the merits, I can simply say that you may approach the.
Your lordship knows about the result, my lord. They will not be doing it since.
Let them not do it. Let them not do it. You will get a fresh cause of action to move this court again, and then that point of time the res judicata will not stare at you. Now the res judicata stares at you. Please consider. Please consider.
I understand your lordship wants to help me. But here is a case now where the substantial justice is being.
No, sir,
impeded.
How best you can do justice to your client, you please consider it. It's better over.
My lord, if I go for the other option without withdrawing, let this lie over here. By interim, I will make an application to them. If they reject, I'll come over again to revive this, so that I can argue.
That is possible. We may say that pendency of this writ application will not be a bar for the authorities to dispose of your writ representation if any filed. Yes. In course of how?
But whether this can also be decided by this court, that is the judgments I am supported with. If I place
let us keep it pending for that. In the meantime, so that you can get a fresh cause of action. But either way, because some pronouncement has been made, your original writ application was dismissed by
Justice Sarangi.
Then you filed a writ appeal.
I filed a writ
What was
appeal.
what was decided there?
Negative equality was attracted. How negative equality was attracted, I could not understand. On the
No, I cannot comment on that, obviously. but what I would like you to address the court on is probably the Justice Sarangi's order and the writ appeal, confirmation of that order in the writ appeal was probably not noticed by me in this judgment.
My lord.
It was not brought to the notice.
Not brought to the notice.
So my judgment may be cited as per inquiry.
I do not want it to be, my lord. Otherwise, I will deprive of
it. I'm just academically asking.
My lord.
Academically, it may be treated as per inquiry.
My lord.
But then there are three orders, as you said, Justice Sanjeev Panda's order and Justice. I followed Justice Sanjeev Panda.
Your lordship has followed justice.
Justice Sanjeev Panda.
Along
Because that was the question there.
with judgments also, your lordship have taken to consideration.
Yes. I have said that you cannot debar them, and strictly speaking, they are Sikha Sahayaks, so they are not regular teachers, and that Right to Education Act and all those things they do not strictly apply. I have actually not entered into that controversy deliberately because at least the person will get some relief that way. technicality ଆଉ ତ କାଟିଦେଲେ ତ ସବୁ
এটা technical aspect is standing before me, my lord. The judgment of the WA that is standing against me. On the first day itself, the case was dismissed on the ground of negative equality, though several of the other judgments of this higher court is there.
All right. Sri S.K. Purohit, learned counsel for the petitioner, submits that his client intends to approach the authority during pendency of the writ application, seeking redressal of his grievance, citing the judgment, citing certain judgments in his, certain judgments of this court as precedent. Stop. Without expressing any opinion, this court holds that pendency of this writ application.
May I pray that without expressing.
In such view of the matter, it is held that pendency of this writ application shall not be a bar for the authority, for the concerned authority to consider and dispose of the representation to be submitted by the petitioner within 1 week from today. List this matter October
ছুটি পরে
25th October.
Right.
Otherwise, these technical I understand your anxiety. Once an order has been passed in your favor, so I don't know how negative equality applies. That's anyway, let us see.
Item number 12.
Here the petitioner files writ application challenging the illegal and arbitrary action of the opposite parties. That is, my lord, the post for Anganwadi helper was to be filled up in Harispur Anganwadi.
That's the opposite parties to publish the advertisement notification afresh, giving opportunity to the petitioner, and then proceed with this. Kon hai chi? What are the facts?
Opposite party number 6 is the only applicant. Opposite party.
No, applicant man kon aaya muluru kon to kon advertisement hala ki kon
advertisement ta kale nahi, publish kale nahi, jota ki rule provide କରୁଛି ଯେ village ରେ କରିବା କଥା, because the opposite party number 5 is the Anganwadi worker and 6 is her daughter. In order to give her the appointment,
Okay.
she has not published the advertisement in the village or in the Gram Panchayat, and she was the only applicant. For that reason, the petitioners and along with other villagers have made application before the collector and the sub collector. That has not been considered till date.
All right, let them consider. Yes, yes. The grievance of the petitioner is that without publishing advertisement.
Advertisement published on 20th December 2020. But he is saying that not in village board.
So
Yes.
it is submitted that the grievance of the petitioner is that an advertisement for engagement of Anganwadi helper in Harispur Anganwadi Center was published
On 20th December 2023.
2012
on 20/12/2023. କେମିତି ପବ୍ଲିଶ କଲେ?
ସେ ତାଙ୍କର ସେଠି ଇଏରେ ଅନଲାଇନ ଆପ୍ଲିକେସନ କରିବା ପାଇଁ କହିଦେଲେ, କିନ୍ତୁ ଗାଁରେ ବା ଯୋଉ
Was published inviting applications online, but without publicizing the same in the village. Yeah, to? Publicizing the same in the village. Stop. As a result, several intending candidates, including the petitioner, were deprived from applying. According to the petitioner, this was done at the instance of opposite party number 5, who is the Anganwadi worker of the said Anganwadi center, only to engage opposite party number 6 as Anganwadi helper, comma, who is none other than her daughter. In this regard, the petitioner has submitted a representation addressed to the collector, to the collector Puri on 6/1/2024.
so also to the sub collector.
Collector को देला पर sub collector कौन? अच्छा हो, and also to the sub collector. It is submitted that no action whatsoever has been taken on such representations so far. See, appointment ହେଇଗଲାଣି?
ନାଇଁ କିଛି ଜଣା ନାହିଁ, ଆମକୁ କିଛି ଜଣା ନାହିଁ।
अच्छा in such view of the matter, the writ application is disposed of, directing the, will direct the collector, the collector Puri to consider the representation of the petitioner, comma, if not already disposed of in the meantime, and to ascertain whether proper procedure was followed in publication of the advertisement in question, and to pass a reasoned order thereafter after hearing all necessary parties. Stop. The order of the collector, the final order of the collector shall be passed within 2 months. Within 1 month from today. Yes.
So write a note 6.
May I plead your lordship? The petitioner was a Gram Rozgar Sevak, your lordship. He was engaged by letter dated 15/2/2020 under annexure 1, space 15, your lordship. Subsequently, a criminal case was instituted against him and he was taken into custody, your lordship, for which he was disengaged from the service from by letter dated 21/12/2023, your lordship. The FIR was registered by one of his colleague, your lordship, with an ulterior motive. With an ulterior motive, your lordship. Subsequently, the petitioner got acquitted from the case, your lordship. That I have annexed the judgment under rejoinder annexure 4.
Rejoinder could assume counter the file,
Counter file each.
Fine.
Counter file each. Counter rejoinder, everything
is not on record. अरे मैं भूलटा खोल ली की
1122
ना 1122 तो खोल ली ये तो काउंटर की
counter rejoinder and everything file, your lordship.
ये फर्स्ट टाइम काउंटर रिजोंडर कितना फाइल है ये काउंटर का नहीं चलो ये था पेपरलेस कोड ये की তাহলে দो ফাইল টা দो तेज में इधर किसी नहीं कौन से করছেন ମୁଁ ଜାଣି ପାରୁନି ସ୍କାନିଂ କଣ ଇଏ ବଡ କେତେ ଏଥିରେ ଏତେ ଅସୁବିଧା ଅଛି କଣ পেপরলেস କରିବାନି ବୁଝିଲ ଆମେ ଫିଜିକାଲ କରିବା ତ ମନା କରିଦେ পেপରଲେସ୍ କରିବାନି ସବୁ ଦିନ କିଛି ନା କିଛି ଗୋଟେ ପ୍ରୋବ୍ଲେମ ହଉଛି ये डॉक्यूमेंट देखला से डॉक्यूमेंट नहीं तो काउंटर रिजोइंडर से सब फाइल अछि किछि नहीं इतने ते सीपीसी को डॉक्यूमेंट सीपीसी को डॉक्यूमेंट हां एगो डॉक्यूमेंट मैं ये मु सेदिन कहली तो तमन किछि से तो मु चीफ जस्टिस को आज कहूछ ये बेकार ये सब बंद कर ठीक है काउंटर रिजोइंडर सब अछि इतने नथिंग इज देयर इंटरेस्टिंग कथा कौन है देखे रिजोइंडर रे
Rejoinder annexure, I filed the judgment under annexure 4, your lordship.
You have been acquitted.
I mean acquitted.
Yes.
Lordship, the para 7 of the judgment.
कौन है क्लीन acquittal?
Clean acquittal. On going through the case record, it
अप्रोच करो तो कलेक्टर गिविंग दिस
Korichi.
रिजेक्ट कर देले
हाँ,
ये रिजेक्ट कर देले
It's 2024 lordship.
रिजेक्ट कर देले
reject for nothing as because he has already terminated me. He is not considering. Rather,
I will direct him to consider ignoring his previous order or what?
and one advertisement was issued. There was annexure 6 here.
Advertisement come out.
But
In the meantime, advertisement come out.
but
एडवर्टाइजमेंट फाइनल सिलेक्शन है नहीं
ना किसी है ही नहीं.
तो है नहीं से रहो होगा नहीं
এই যে 23/9/2024 पर last date of submission of application for.
इन द मीन टाइम से आगे इतो कंसीडर करो को तो ये तेरे क्या पीछे अपन हम क्या पीछे ना कौन तो subsequently has been acquitted
Yes.
so let him consider without being influenced by his earlier order what do you say Mr. Das
If that acquittal is honorable acquittal.
Yes, sir. Lordship.
honorable acquittal कोर्ट मुझे जानने आ गया सेशन जज चाकरी कोली तीनटा जगह honorable acquittal dishonorable acquittal मुझे चिन्ह नहीं
Not dishonor, the benefit of doubt.
I don't know why
It is benefit of doubt है नहीं lordship. से कहूची जे मु रागरे एफआईआर କରିଥିଲି. Para 7 of the.
no he says I come to an irresistible conclusion that the prosecution miserably failed to prove the charge against the accused persons
The finding of the court.
the state also has some objection to this word miserably failed When I was law secretary, so that point was taken by the Director General of Police. Then, yes, sir, why are the judges writing miserably failed? I said it must be their language. What can I do? So this means that honorable complete is acquittal, isn't it? The petitioner was working as Gram Rozgar Sevak of GP.
Your Lordship. Ghatmal GP.
Huh?
Ghatmal GP.
Ghatmal GP.
Under Sinapali block. And
And sir, want serial number केते कोना दे?
transfer ହେଇଛି ନା.
अपन original टा कोटे अपन हेले कोन तो transfer टाइम को लिख परिए ने?
Initially, I was appointed under Jadumunda GP.
The petitioner was appointed as Gram Rozgar Sevak of Jadumunda GP on
On 15 to 2020, Your Lordship.
15 to 2020. Subsequently, he was transferred to
Ghatmal GP
Gotmal GP
under Sinapali block.
under Sinapalli block. Stop. While working as such, an FIR was lodged against him at the instance of one Kontana Sarita Biswas. One Konata Urlita Biswas, sorry. Susri Urlita Biswas before the Nuapada Sinapalli police station, which was registered as PS case number 304 dated 12/11/2023 under sections 294, 307, 323, 34, 323, 354, 34 IPC, 354, 354 capital B, 452, 506 of IPC. Stop. Basing on such, in view of initiation of such criminal case against him, the collector cum CEO Jila Parishad Nuapada in his order by order dated 21/12/2023
He was taken to custody for which
terminated the contractual engagement of the petitioner and directed his disengagement with immediate effect.
As
Stop.
per the clause 25th of the agreement.
Yes, sir.
Yes.
The petitioner was subsequently acquitted in the criminal case being ST case number 29/06 of 2024 by judgment dated 12/7/2024 passed by the learned senior civil judge, bracket to Women's Court, Nuapada. Stop. It is submitted that said acquittal was an honorable acquittal inasmuch as the prosecution could not prove the charges against the petitioner. Stop. As such, it is prayed that the petitioner should be reinstated in service. Stop. This court is of the view that the impugned order was passed only because the petitioner was involved in the criminal case and had been taken to custody for some time in connection therewith. The petitioner has since been acquitted of the criminal charges in view of the aforementioned judgment. Stop. Therefore, the concerned authority can always take note of this development if the petitioner is granted liberty to approach him by submitting appropriate representation. The writ application is therefore disposed of, granting liberty to the petitioner to submit a representation before the collector, enclosing copy of enclosing certified copy of the judgment of acquittal passed in the criminal case. And by making necessary prayer. Stop. If such representation is submitted within the stipulated period, comma, the collector shall do well to consider the same, consider and dispose of the same in accordance with law without being influenced by his earlier order. The collector shall pass final order after granting an opportunity of hearing to the petitioner within 1 month from today. That's all, Mr. Mahapati?
Till then, one post may be kept reserved, your lordship.
Yes. It is submitted that in the meantime, an advertisement has been issued on 22/8/2024 to fill up the post of Gram Rozgar Sevak, including for co-GP, Gram Rozgar Sevak. Hala?
Of Noapada district.
Ah.
Under Noapada.
It is therefore directed that one post of Gram Rozgar Sevak shall not be filled up till disposal of the representation of the petitioner by the collector. Yes. Yes, Mr. Somyo, the same problem. This is the case. This is a case where the counter has been filed, rejoinder has been filed, everything is there, but in the scanned record, nothing is there. So I was naturally I asked the counsel, where is the counter? He says that I filed, there is a state says I filed a counter. He says I filed a rejoinder. Nothing has been scanned. So please ask the scanning authorities. They're not applying their mind at all. So the entire record, only half of it has been scanned. And particularly in civil cases, now that you are here though, and in particularly the LCR, like in our civil court, the Sirastadar, he is trained to do that LCR. They are it is just proving to be very, very difficult to find out the documents, the exhibits and the whatever has been filed. They are scanning time petitions and haziras, leaving out the major exhibits and all. And this is a case you ask him to improve. Otherwise, I will pass a judicial order.
Item 13, pattern matter.
Item 13 on behalf of Mr. Pradeep Pardas, I pray taken up next Monday.
Monday may go.
Due to illness of his mother, he has went to the village.
Who?
Mr. Pradeep Kumar Das Mel.
You want to say, let it come next.
Yes, ma'am.
As requested by learned counsel for the opposite party. Let this matter next week.
Item number 14,
Supreme Court has seen matter. No,
My lord, I
Yes.
beg pardon.
Yes.
My lord, in fact, the physical handicapped lady, the petitioner, she could not able to come cut off from due to some her personal difficulties. My lord. One rejoinder is ready, my lord, to file the case by giving some certain documents relating to her case. My lord. 2 weeks में time, 2 weeks only.
All right. I will grant it, but I will read out 3 orders. On 7/8/2024.
Yes, my lord. I am sorry for that. Due to said demise of my uncle, my lord, I could not able to appear before my lords, my lord. That's why, my lord.
Sarla Muti Koivi. 7 non appears for the petitioners on repeated calls. 22 non appears for the petitioner on repeated calls. 23 non appears for the petitioner on repeated calls.
Sorry,
matter 2013.
my lord.
11টি বসন্ত অতিক্রান্ত হইসারছি এ ভিতরে বুঝলে তো কেবে সে
ଶ୍ରୀଦେବୀଙ୍କ ଲେଖା ଆଉ କବିତା ଇଏ ଆଶାର ଏଇ କଣ ମୁଁ ମୋ ମୁଣ୍ଡରେ ପଶିଗଲି।
All right. This matter next week as paid for by Sri Rai. It is made clear that no further time shall be granted.
item number 15,
Yes.
For going to the merit of the case, my lord. Your lordship had the matter 2 to 3 times.
You are challenging the order of the RDC?
Yes.
Report of the RDC?
Yes. Before they're going to merit, Yeah, so some facts are involved in this case. On the last occasion, Lordship categorically held that whether your Lordship on sitting on under 222 can hear the facts or not. In this regard, I will clarify Lordship to decision of the Honorable Accused. I have just some.
Yes.
Safety key to move to bullying, the move, set a move, a competence. In this regard, I am submitting a decision of 2004 3 SCC 553, that is AB in ABL International
Yes.
Limited and others expert. Your Lordship may come to the para 16 of the judgment. Para 16. May I permit to read?
Yes, please.
A perusal of this judgment, though shows that a writ petition involving serious disputed questions of facts, which requires consideration of evidence which is not on record, will not normally be entertained by a court in the exercise of its jurisdiction under Article 226 of the Constitution of India. This decision, again in an opinion, does not lay down any absolute rule that in all cases involved dispute questions of the fact, the parties should be relegated to the civil suit. In this view of ours, we are supported by a judgment of this court in the case of Srimati Gunwat Kaur and others versus Municipal Committee, Bhatinda and others, Manu etc., where dealing with such situation of disputed questions of fact in a writ petition, this court held. The High Court observed that they will not determine disputed questions of fact in a writ petition, but what facts were in dispute and what were admitted would only be determined after an affidavit in reply was filed by the state. The High Court, however, proceeded to dismiss the petition in live. The High Court is not deprived of its jurisdiction to entertain a petition under Article 226 merely because in considering the petitioner right to relief question of facts may fall to be determined. In a petition under Article 226, the High Court has jurisdiction to try issue both of fact and law. Exercise of the jurisdiction is true. Discretion.
If it is true, easy.
Discretion, but the discretion must be exercised on sound judicial principles. When the petitioner raises question of fact of a complex nature, which may, for their determination, require oral evidence to be taken, and on that account, the High Court is of the view that dispute may not appropriately be tried in a writ petition. The High Court may decline to try a petition. Rejection of a petition in lifeline will normally be in limine will normally be justified where the High Court is of the view that the petition is frivolous or because of the nature of the claim made dispute sought to be agitated, or that petition against the party against whom relief is claimed is not maintainable, or that the dispute raised thereby sought that it would inappropriate to try in the writ jurisdiction or of analogous regions. From the averment made in the petition filed by the appellant, it is clear that in proof of a large number of allegations, the appellants rely upon documentary evidence and the only matter in respect of which conflicts of facts may possibly arise related to the due publication of the notification under Section 4 by the collector. In the present case, in your judgment, the High Court was not justified in dismissing the petition on ground that it will not determine disputed question of fact. The High Court has jurisdiction to determine question of fact even if they are in dispute, and the present in our judgment is case in which the interests of both the parties, the High Court should have entertained the petition and called for an affidavit in reply from the respondent and should have proceeded to try the petition instead of relegating the appellants to a separate suit. Then your Lordship may come to para 70. The above judgment of Srimati Gunwat Kaur Supra finds support from another judgment of this court in the case of Century Spinning and Manufacturing Company Ltd and others versus the Ulsanagar Municipal Council and another MNU. Merely because a question of fact is raised, the High Court will not be justified in requiring the party to seek relief by the somewhat lengthy, dilatory and expensive process by a civil suit against a public body. The question of fact raised by the petition in this case is elementary. Then your lordship come to the para 17 also. 17, then your lordship come to para 19. Therefore, it is clear from the above renewation of law that merely because of one of the merely because one of the parties to the litigation raises a dispute in regard to the facts of the case, the court entertaining such petition under Article 2 to 6 of the Constitution is not always bound to relegate the parties to a suit. In the above case, Srimati Gunant Kaur Supra, this court even went to the extent of holding that in a writ petition, if facts required, even oral evidence can be taken. This clearly shows that in an appropriate case, the writ court has the jurisdiction to entertain a writ petition involving disputed questions of fact, and there is no absolute bar for entertaining a writ petition, even if the same is arouses of a contractual obligation and or involves some disputed question of fact.
Yes, Mr. Sethi. So, that in an appropriate case, the writ court has jurisdiction to entertain a writ application.
Yes.
So, whether this case is an appropriate case, that has to be considered.
Your lordship, I am taking your lordship para 29 also.
Oh, 29 कौन हो?
Yes. 29. Para 29. Except the following legal principle emerge as to the maintainability of the writ petition. Merely because of this, be it as sir, merely because some disputed question of facts arise for consideration, some cannot be ground to refuse entertain a writ petition.
So that point is there. That point is accepted. That point is not in dispute at all. In many cases, also this court also entertains questions of fact. But here, what has happened is this court directed the RDC to conduct an inquiry.
Yes.
He has conducted an inquiry, a factual inquiry, and he has arrived at some findings.
Yes, ma'am.
You have to show how those findings are wrong.
Yes.
Only to that extent the court is willing to see the facts.
I am very much obliged.
Whether they are on the face of it wrong.
Yes.
Otherwise, the court, why should the court entertain into that? He is the fact finding authority.
Yes, your lordship.
Why will this court substitute its opinion for that of the RDC?
Yes. Only I will take your lordship.
Where is the RDC's inquiry?
RDC's inquiry report as a consolidated petition at annexer. And consolidated petition, it a file is annexer. 10.
Anyway, the inquiry report is otherwise available.
Yes, my lord. That is separate report, your lordship. Yes. Got it, my lord?
Yes.
Then I will the operative portion of the RGC report. Here in the last the annexer, no, I guess, is your last page, last 2 pages. As per the order of Hon'Ble High Court. In the matter of determination of whether there is evidence of any manipulation of tampering in the original notification defining the service area of Khannagar Mini Anganwadi Center is also the advertisement dated 16/2009. Through inspection of the records was done. During inspection of various files, 3 different copies of the advertisement dated 16/2009 were found. The selection committee met on 13/3/2012. In the copy of the original advertisement in the selection committee file, there is no mention of Majipada in column 7 or 8. Only Khannagar is mentioned in column 7 and 8. Then in the B, in another copy, the original advertisement in the official file, there is a deletion of a word in column 7 and had it in addition of Majipada only was added in column 8, but without any initial such signature. The ADM Kendrapara refers to this fact in his order dated 24/10/2013 in case number such and such. Then we'll have C, only C. In another ink signed copy of the original advertisement in the official file, there is a deletion of word column 7 and a handwritten addition of Majipada also in an initial such signature is observed besides in column 8 However, it is difficult to ascertain as what is initial as there. Then your lordship on the next page. The D. The order of the ADM Kendrapada dated 24/10/2013, copy of the order the Kendrapada dated is annexer K. From the above evidence, it can be clearly established that there was indeed a tampering of the original advertisement. From the facts available, it can only be interpreted the word Mojipoda was added by hand sometime between 13-3-12 and 24-10-13, and in short signature was added in 24-10-13. However, the culpability for this tampering could not be established. Though the ADM in his report dated 24-10-2013 aside, it is to the BDO who was the in charge CDPO. This is the operative portion of the. Let me, your lordship may come to your lordship's order dated on 30/4/2024. Got it?
Yes.
As per your direction, your lordship's direction, the original file was before your lordship, and after verifying and perusing the original file, your lordship passed this order. I may permitted to read your lordship's order. As directed, Mr. Patnaik, lawyer, additional government advocate, has produced the original file containing the report of the committee regarding determination of the service area of different Anganwadi, mini Anganwadi centers of Kendrapada district. He points out that the service area of Khannagar mini Anganwadi center is mentioned as Khannagar Mojipada. Khannagar, Mojipada Milad. This court also has perused the said report. The file also contains the original advertisement dated 16/12/2009, where the service area is mentioned as Khannagar Mojipada with initial of someone. The name of the mini Anganwadi center is mentioned as Khannagar, and the word Mojipada appears to have been scored through. As compared of these documents, the affidavit filed by the collector Kendrapada on 16/2/2023 is to the effect that Mojipada does not come under the service area of Khannagar mini Anganwadi center. This court further takes note of the impugned order under Annexer 1 passed by the ADM, wherein headlines follows. From the joint inquiry report of the DSW Kendrapada and the CDPO database, it is clear that the original name of the mini Anganwadi center is Khannagar. It has been manipulated and tampered in the instance of CDPO database. This court has clearly mentioned the fact of manipulation in his order dated 24/10/2013. Therefore, the DSW Kendrapada is directed to cause an inquiry into such manipulation and take appropriate action against the person at fault. As per the joint inquiry report, the respondent number 2 belongs to Mojipada Hamlet, which is coming within the territorial jurisdiction of Revenue Village Ortamod. The resident certificate issued by the Tahsildar database by case number such and such corroborate the same thing. Therefore, it is clear that the respondent number Sanjukta Dale belongs to Hamlet Mojipada under Ortamod Revenue Village. Further, the area of operation of the mini Anganwadi center is only village Khannagar. As such, the respondent number 2 is not coming within the jurisdiction of area of operation of mini AWC Khannagar. Therefore, the candidature of the respondent number 2 was required to be rejected at the time of scrutiny. But as stated above, due to manipulation, tampering in the advertisement, the respondent number 2, Sanjukta Dale, got engaged as Anganwadi worker in Khannagar mini Anganwadi center. It is quite obvious that the facts are not clear at all in as much as there is material show that Mojipada is included within the service area of Khannagar mini Anganwadi center, whereas it is also stated that the same appears to because of manipulation and tampering purportedly at the instance of CDPO database. There seems to be a report of the DSW Kendrapada at Annexer C/2 to the counter, as per which Mojipada does not come within the service area of Khannagar mini Anganwadi center. Nothing has been stated as regards the so-called manipulation of the original notification advertisement. This is your lordship's observation order on dated after verifying, after perusing the original file. Then your lordship will come to the previously counter filed at annexer. My lord, at annexer.
Wait, you did not read the remaining portion.
Oh,
This
sorry.
court therefore deems it proper to direct the RDC Central Division
Yes,
Clerk
we-
to conduct an
sorry.
inquiry himself without delegating it to any other functionary. The scope of inquiry shall be to determine whether Majipada is included within Hon'Ble Mini Anganwadi Center and whether there is evidence of any manipulation, tampering in the original notification defining the area of Hon'Ble Mini Anganwadi Center, as also the advertisement dated 16/12/2009. So he has found that there is tampering.
There is a tampering kotha se kohunate kya. Only he is saying that. He is saying that that the area of operation is only for Khannagar, not for
No,
Bajaj.
he says from the above evidence it can be clearly established that there was indeed a tampering of original advertisement. The board going underline করছে দেখুন. That is his finding.
That has not tampered with. Your lordship has verified the original record. Your lordship has verified the original record. Then your lordship passed this order. Your lordship has verified the original. Then your lordship come to the page. Your lordship will come to the page in the writ petition. Page, my lord.
You are whipping a dead horse, Mr. Pratap.
No, my lord. No. Your lordship can page to page 38 in the writ petition. Kindly come to page 38. No,
I have heard this matter maybe for the longest during my tenure.
kindly go once.
I directed the RDC to conduct an inquiry specifying the terms of reference.
Again.
Now the RDC comes out and he is a responsible officer, senior IS officer. He has given a finding and he has given a very reasoned order.
Again.
You have challenged it, undoubtedly. But unless you can show how it is wrong on the face of it, why will this court interfere?
Then I am just submitting, my lord. As per your lordship's direction, original record is produced before lordship.
I have never held that there is no tampering. I said that it is not clear what has happened. That is why I directed him to inquire and whether there is a tampering.
That reason I am taking your lordship page 38. Only for a moment, your lordship page 38 of the writ petition.
Yes.
Para 4. It is a counter filed by the opposite party number 1, 2 and 3.
Yes.
Para 3, 4. That it is submitted that on the basis of advertisement dated 16/2009 issued by the CDPO for the post of Anganwadi worker in respect of Khannagar Majipada Mini Anganwadi Center. In the counter, they have admitted that the collector as well as the CDPO admitted that it is both for Khannagar and Majipada, not.
Anyway, but this court rejected the report of the collector, saying that is why direction was given to the RDC to inquire.
Again.
That's all.
Into advertisement, sir.
I can keep it to tomorrow. I think Mr. Patnaik will appear tomorrow.
Yes.
Mr. S. L. Patnaik.
Yes.
Since he was dealing with this matter
Yes, yes,
all
better.
through, it is better.
Again.
Heard further arguments. Let's this matter tomorrow.
Tomorrow, sir, doctor appointment next week. So.
The next week, also.
Again.
Chapter again. କାଲି ଆସୁ କାଲି କଣ ହେଇପାରିବନି
11 ଡକ୍ଟର ଆପଏଣ୍ଟମେଣ୍ଟ ନେଇଯାଇଛି ଆରେ ମୋର କାଲି ଶନିବାର କୋର୍ଟ ଅଛି ମତେ ଆରେ ମଦନଙ୍କର ନେଇଛି ମୋର
so 13 September
13 September
yes
I do not see.
I am virtual. Mr. Mahapatra, who is appearing for the opposite part number 6, has not sought a copy on me. I mean to say my associate. And there was the order that the matter will be listed on 23/9.
No, 23/8. Inadvertently, it has been mentioned.
Even if there is a
My not detected before.
so what copy you have to serve a copy
may I allow this?
You have said you have sought the copy.
no
Copy has not been served.
copy of what
About the counter of mine, that is what has happened. You also may remember that the original counter was with the state council.
okay
So therefore, it was submitted with the copy sought upon him. That my non.
you serve a copy otherwise how can we proceed
My lord, apart from
I
that,
would have
What pains me, let me tell your lordship, my lord, what pains me.
But it is a writ of certiorari. Your lordship may kindly see the order.
Allow me to my submission. What pains me, the matter was directed to be listed on 23/9/2024. If there is an inadvertent error, the other party who mentioned before the lordship should minimum intimate the counsel of the other side or file a mispetition to attend at this thing. This is against the discipline of judiciary. What nonsense?
Your lordship may just visualize one thing.
No, I will.
Before my learned senior, it was directed to be listed on 23/8. In May, it is shown that it is to be, the date of posting is 23/8. But the order sheet, it is 23/9.
So for that,
Anyway, Jahabi, you serve a copy of your counter. Let it be regularized. We can take it up.
Then
On any day.
opportunity. You cannot make a
Get a
mention.
copy of the counter.
and move
Filed by opposite party. Mr. Mahapatra, you are for the opposite party?
opposite partner 6 lords.
Another
matter is there, my lord.
Just a moment. Let a copy of the counter affidavit filed by opposite party number 6 be served upon the counsel for the petitioner by Monday. Yes, Mr. Mathi?
My lord, my matter may be had. Now, my lord, he is having some difficulty with regard to the counter filed by Mr. Mahapatra. I had sought my copy of my counter to him. Still, my lord, in my case, he is OP number 5. I think, my lord, that case is ripen enough to be heard. It is
No, if it is connected to this matter, let both the matters be taken up together.
My lord, may kindly visualize.
Why will I segregate these?
No, it's not a question of segregation. My lord, my learned senior makes out an objection to this. But your lords may kindly visualize. This is a case of 2016. And my lord, when I approached this honorable court way back in 2016, this was issued. There, my learned senior appeared for opposite party number 5, who is the petitioner over here. Her very selection was challenged by another candidate belonging to the very same Anganwadi center, who was also a candidate in Anganwadi appeal. Now, in the Anganwadi appeal, her selection was set at not on the ground that she was ineligible to make her application even. Her application.
Anyway, will there not be a conflict of orders? So let both these cases be taken up together any day. You say.
My lord, your lordship fix. So my humble prayer would be, your lordship fix this matter to next week, so that it's a parted matter, and on his presence the matter is fixed to 23.
No, both the matters shall be taken up together.
Yes, I don't say it should be segregated. I say, my lord, both the cases may be taken up next week after, as per your lordship's convenience.
Next week will not be possible.
It's a parted matter, your lordship.
The copy of the counter is not received.
No, I call it. Affidavit going to court today. No. I'll call it on. I'll call both these matters on 13th, because next week on 5th or on 6th I already have some parted matters prefixed. So I'll call it on 13th. Yes. Place this matter on 13th. Yes.
The clerk could let him be the solved with the
Opinion.
Charan.
Item number 17.
Yes. Item 17.
What is this?
17 last agreement directed me to obtain instruction about the date of application for issuance of residential certificate.
Yes.
That note I have not obtained because I have already sent the message. I have not.
Sri Pradhan Learned Counsel with the petitioner request for some time to obtain the necessary instructions. Place this matter on.
Any day next week, Lord.
Next week, Hobon.
All right, my lord, madam.
20th September.
Item number 16 lords may say I had solved it.
Item 16, right? Copy of the counter is served in the court.
Item number 18.
My lords, item 18. My lords, we have sent a letter to the petitioner regarding the status of the posting. So she has not given us any instructions for the same, my lords. My lords, let it come after 2 weeks. The letter has not yet reached.
27 September as requested by Learned Counsel for the petitioner.
I'm on behalf of Mr. A.C. Swai, my lords.
Item number 19.
Obliged.
Yes. Your 2011 matter.
Yes, my lord.
Does the cause of action survive anymore?
Yes. Initially what happened, pursuant to the advertisement made by the CDO Kumna Punchas Samiti in district of Nuapada,
petitioner number 2 was applied for the post of Anganwadi worker. The petitioner was selected as Anganwadi worker and he was appointed. Assailing the same, OP number 5 preferred appeal before the sub-collector Noapada. The appellate authority was pleased to allow the appeal by setting aside my appointment. That is under challenge. Lordship, see.
Appeal memo.
Yes,
Appeal. Order. Annex 3.
yes, Annex 3 the impugn.
Won't.
Lordship, that. Lordship, see the. Prior to that, you also kindly come to page 24, my lord. Prior to the impugn order.
24.
Yes, page 24 is what. Yes. That the comparative statement for selection of Anganwadi worker under ICTS project Kona Colony Pada Anganwadi Center. Here, my name is at serial number 1. That Bina Patel. The other side, that Urmila Savar, who has assailing my appointment by preferring appeal before the appellate lordship, she has secured. Yes, I have got 48.33 mark because I have with +2 qualification to my credit. For HSC 43.23 and for +2 mark, I have added 5 mark, that is 48.33 mark. So, OP number 4, that serial number 2, Urmila Savar, she has secured 44.66 mark. And for that, since she belongs to scheduled tribe category, she was given additional 10 marks. Lordship, then I may bring to lordship to the guideline governing the field of selection and appointment of Anganwadi worker.
10 marks, 10 points to the
No, that is there, but lordship, HSC qualification is the one must be a resident of Anganwadi center area, must. And second precondition, person having highest qualification in HSC is to be taken into consideration, madam.
No, shall be on the basis of drawing a merit list.
Yes.
Merit list ko jate. In addition to the above.
Yes, I am coming to lordship, see page that revised guideline date 25/2007, madam. Lordship, see that that revised guideline with clause 3. Yes, that subclause. Percentage of marks obtained in the examination, matriculation examination shall be the basis for drawing merit list among the applicants. Whoever having highest mark or candidate is to consider. In addition to the above, preferential additional marks will be given. So far, she is belong to scheduled tribe, he is given 10 marks. Here, since I am having +2 qualification and I have been having highest mark than that of the other side, I was rightly appointed. But the ADM, what he did, he allowed the appeal saying that I am not coming within the, I am not a resident of Anganwadi center area.
My lord, I am in virtual mode, my lord.
Yes.
I am appearing for opposite party number 6 in this case.
Yes.
Who has been selected, my lordship, as Anganwadi worker, and subsequently the present petitioner had filed appeal before the ADM, and I was declared, my appointment was declared illegal, and my lordship, more important is, your lordship will find from page 32 of the writ petition, 32. What is the ground of rejection?
There is no page 32.
No page 32. My senior, maybe no, item
28.
Probably you are in another matter. Which item are you referring to?
Item number 18. Item 18, my lord.
It's already adjourned.
It was 19. Well, this is item 19.
My lordship, 18 was adjournment.
It has been adjourned to 27 September. Yes. Who is appearing in your case, Mr. Joshi? Who is appearing?
Mr.
Krishna Chandra Das. Anyway, he is not there. Concrete.
Yes. My proceed. Yes. Yes. One is, I also the guideline govern the field 2.5. The one must be a true precondition
to be appointed as Anganwadi worker. One must be a resident of Anganwadi center area and person having highest mark in the HSC examination is to be the mode of selection. Your Lordship, see, so far the petitioner is concerned having 10+2 qualification to her credit. She has admittedly obtained 43.44 marks in HSC qualification, and for +2 qualification she has given 5 pages per mark. So if the entire mark is taken to consider, I have got 48.43 marks. Whereas the OP number 4 has secured, you also see the page 24, she has secured 44.66 mark. Since she belongs to the scheduled tribe category, she was given additional 10 marks. And total mark comes to is 54.6. My lord,
The guideline says so. The basis of drawing the merit list, basic merit list is to be found on the basis of marks secured in the HSC.
HSC, yes.
In addition to that, these marks will be given.
Yes.
So the total mark will be calculated that way.
Yeah.
So nothing wrong.
You also see the order passed by the appellate authority.
I've seen it. I'm just
The ADM of the view that I do not belong to the Anganwadi center area. So far, the advertisement concerned the petitioner, 2 others applied. And since among all the 3 candidates, I am the only one candidate belong to the Anganwadi center area. 2 other candidates I belong to additional Anganwadi center area.
Where is it mentioned here, my lord? Where is the finding? The finding is at page 20, on perusal of survey report.
Yes, page 20. On perusal of the surveyor's report produced by the CDPO Kumna, it is seen that at least at last page, the lady supervisor signed the same on 23/3/2010, but there is no authentication of the same in every page. Apart from the survey list, the same has been prepared after issue of notification for filing of the post of so-and-so, Chandropola, Colony Anganwadi Center, prepared before 26 days prior to selection of Anganwadi worker. That fault do not lie with me, my lord. If at all this.
Yes. Read it.
Yes. Further, it reveals from the comparative statement prepared by the selection committee for Chandropola, Colony Anganwadi Center, Srimati Urmila Sir has been awarded 54.66 points, whereas the respondent number 2, Srimati Bina Patel, has been awarded 48.33 marks. Selected her for the post of Anganwadi worker for the said Anganwadi Center, which reflect the integrity and transparency of the selection process of the selection committee under the chairmanship of Sub-Collector Nuapada, come chairman of the ICD Exposure Komna, as well as the convener of the selection committee. The BDO Komuna, who was in charge of CDPO Komuna, was supposed to place the relevant documents and prepare the proceedings of the meeting in accordance with the provision of the guidelines and responsible for publication of result. Engagement of Anganwadi workers and the ICD Exposure Komuna. In the circumstances, I am constrained, I am set aside the selection process as well as engagement of respondent number 2 as so and so. From so and so.
He does not give any finding that you do not belong to the service area. My lord, he has not given any finding that you are you do not belong to the service area. He has noted the marks that she secured more marks than you and she was selected, rightly selected. कौन करिए?
ଆଉ ସୁମାର ଥାଉ ଅଦର
ନାଇଁ ଆଉ ରଖିବା। 2011 ମସିହା ରଖିକି କଣ ହବ?
Yes.
ଯଦି କିଛି ଥାନ୍ତା ତା ଦେହରେ
Yes, yes.
ରଖିବାକୁ ମନା ନାହିଁ। କିନ୍ତୁ କିଛି ନାହିଁ ଆଉ। ଯେ ମୂଳରୁ ମୃତ ତାକୁ ଆଉ
ground like to place the grounds I have taken in the
କଣ ପାଇଁ ଗ୍ରାଉଣ୍ଡ ପ୍ଲେସ୍ ବୁଝି ସାରିଲେଣି ସବୁ ଜାଣି ସାରିଲେଣି ଆଉ କଣ?
let me place it. Look, ground number A. Colony Poda Anganwadi Center consists of Bagpoda, Bholpoda.
ସେ ଫାଇଣ୍ଡିଂ କିଛି ଦେଇନାହାନ୍ତି ସେଇ ଗ୍ରାଉଣ୍ଡରେ ସେ ରିଜେକ୍ଟ କରନ୍ତି ତାହେଲେ ଆପଣ କାହିଁକି ସେ କଥା ଉଠେଇଲେ କଣ ହବ? A dead person cannot be more dead.
No. Once a person is appointed as Anganwadi worker, normally she should not be disengaged unless any serious or persistent lapses is marked on her. That is the one of the precondition. The appeal was filed at the instance of OP number 4, and my appointment was set aside.
Is there any interim order in your favor?
No interim order.
Well, the petitioner has approached this court with the following prayer. Pursuant to an advertisement issued for engagement of Anganwadi worker.
One more thing, just clear. Page 6, clause D. One.
Page 6?
Page 6, clause D of the ground bill.
Page 6 of the writ application?
Yeah. It is clearly reveals from the survey list in respect of Chandurpala, that is Chandurpala village is concerned, the petitioner name found place in respect of house number 47 of the said list, whereas OP number names do not find place in respect of said village.
45069. Oh, hard copy there. चारि अच्छी 5-6 नहीं ये देखो 5-6 करना स्कैनिंग इन देखो 4 पर 7 ये नोट को रखो हाँ मेरे जे चीज चीज को कोई सब बंद कर देले जीव ये बेकार ये पेपरलेस काम दउन तुम 4 पर सीधा 7 5-6 पेज नहीं ground at page 6 ground number
Clause D. It is clearly reveals from the survey list in respect of Kolonipada, that is Chandpola village is concerned, the petition name is found place in respect of house number 47 of the said list. Whereas OP number names do not find place in it. What is your counter?
Counter, we have supported the appellate order, that's all.
no where is the selection
No, they have not disputed the same. They have supported the learned ADM right to allow the appeal.
look
I think
here no he has a point. He may have secured the highest points.
Yes.
But it is clearly mentioned there out of Anganwadi center area. So the petitioner was rightly engaged.
If that is so.
Yes.
Yes.
Come to annexation 4.
Yes.
Sir.
Page 24.
Out of Anganwadi center area.
Yes, out of Anganwadi's remarks column.
If she is not a member, if she is not a resident of that service area, how can she be selected? So naturally, rightly the petitioner was selected. Only because she has secured the highest marks, she has been, her candidature should not have been considered in the first place.
If not of the area.
So you find out what is the present status.
And no finding by the appellate authority.
But in part, let this matter. 20th September. In the meantime, London State Council shall inform the present status of the Anganwadi center in question. Yes. As to who is, as to who is working as Anganwadi worker in this center.
At present, OP number 45. After.
Yes.
Item 20.
As it first letter, the schedule and counsel for the petitioner is present. Sri Yadas, Leonard AGA is also present. None appears for the opposite party number 4. This being a case of the year 2011, is therefore taken up for hearing. But in part, let this matter on session. Yes.
Next week.
No, 20th.
Well, on item 20, I mean, an additional affidavit stating therein that the counter.
You are filing?
Yes, yes. And for the petition. In the counter, as well as the appeal petition, the petitioners are denied that the opposite part number 3, with the appellant has denied that there was no proceeding. But here I am filing a document that the proceeding was initiated, so called notice was given, and he has also replied to the so called notice.
Sharma, Leonard counsel for the petitioner.
In this case, I am appearing
files an additional affidavit in the court after serving copy on the other side. Yes.
My lord, I am appearing for the OP number 3. Initially, they have terminated my service in the year 2008. I prepared an appeal before the State Education Tribunal. I was succeeded. After succeeded my appeal, they have not given the permission to joining in my new in my post. Till today, I am retired. Each and every day, my learned friend giving a new story that initially disciplinary proceeding was initiated. I had given the reply. Today, my learned friend filed the additional affidavit. My simple grievance, my lord, when my services was terminated under section 10A, they have taken the prior approval of the director. If they have taken the prior approval of the director, I have no case.
The problem is he has given an additional affidavit. If you are ready to argue on it, let us take it up.
Yes, madam.
Yes, quote. Yes.
Taken up on Monday.
Monday, Havani.
Next week.
Hmm?
Next week.
Please this matter next week.
In the year 2011 matter, my lord.
Next week, yes, I will work.
Item 21.
Yes, item 21.
I'm for the
Anybody for the petitioner?
I'm for the OP6.
One pass over, देखिए. Yes.
22.
Well, next to you.
Yeah, देखिए. If he doesn't come, I will.
Yes, sorry.
I'll dismiss it.
I'll
Item 22.
Item 22, I am appearing for the petitioner. The last two occasions, the lordship has directed the London State Council to file the counter, your lordship.
The counter has not been filed.
Because copy has not been solved, so I am noting is not there.
Yes.
But file is not there with me.
Last time it was submitted that complete Paravo's comments have been received along with documents and that you require some time to file counter. This was on 9th of August.
Kali document, let me verify.
Or let it come tomorrow, thereafter we'll adjourn. We'll just matter tomorrow.
Item 23.
23. Your matter, Mr. Mahapatra?
My lord. I am for the petition, my lord.
Yes.
Well, advertisement made by the government for fill up the grammar Seva.
Lordship, in this case, I'm for OP5. It will come next week. I will file the
Oh, my-
counter, your lordship.
By taking time since it 19 till today, they have whenever the case take up, they have taken time. They have taken time.
In 2021, we appeared, your lordship, but we have some documents, but there are need.
On the other hand, government has filed already the counter, and I have already filed the reason.
But the private opposite party.
Yes, your lordship.
Is the counter necessary?
No.
Or
So they are challenging the procedure, your lordship.
You have been appointed against the
Appointed.
termination vacancy.
Yes, your lordship.
So, what counter?
Termination. No termination.
I've been appointed. I've been selected and been appointed, your lordship, and working, continuing since 2017. So if at all they will succeed, your lordship, then I may be affected. That's why I need to file it.
No, you will be affected certainly. That is why you have been made a party. So,
Let him continue, your lordship.
if counter is necessary, I will grant to time.
I will file the joining letter and other documents here.
So that is not disputed. Your selection is not disputed.
But one document, neither the government filed nor my learned friend filed.
You can file it through a memo also. If it is considered relevant, it will be taken on record.
Yes.
Yes, Mr.
Let him
Singh.
continue.
My lord. Page 18, the advertisement is made on the basis of the 10 plus 2 qualification. The person will be selected and appointed. Your lordship may kindly turn to page 30, my lord. My mark sheet, my lord. My plus 2 mark is 428. Opposite part number. Opposite, your lordship may can turn to page 37, my lord. Opposite party has got mark 390. Your lordship may kindly have a glance. Page number 43, my lord. Your lordship has got, my lord.
Rasmita Pali is selected as GRS.
390 रे ताको सिलेक्ट कले मोर आगे दे दे 222 मोर आगे 428 your lordship has got the mark page 30. I have got mark of 428, but office mention page column number 8 as 222. Whereas Rasmita open number 5 who is selected, he has got mark 390 selected and as one.
That is the only case.
That's only one case.
So then the state has to. There seems to be an error, probably.
I am appearing for the opposite party numbers 3 and 4.
3 and 4 are?
Opposite party numbers 3 and 4, that the project director DRT and the DPC come collector Puri. The short fact is, my lords, actually there is a clerical error. We have admitted, my lord may kindly see my counter. Counter affidavit filed by opposite party number 3 and 4.
Yes.
At page 3, para 8.
Para 8.
Very simple thing.
Yes.
Actually, किसी को अच्छा नहीं है. In reply to the government, it is submitted after submission of the application form as per the advertisement. The office of the opposite part number 3 has scrutinized the documents and prepared the selected of respective Gram Panchayat as per the candidate wise. It may be mentioned here that during scrutiny and preparation of selected, it has wrongly been mentioned the mark of matriculation was wrongly put in place of +2 mark of the petitioner, which is a clerical mistake. Only ground we have taken, my lord, after the objection period it was advertised, after 1 year, 9 months, he has filed the objection. That is our only stand we have taken.
No, you cannot take advantage of your own.
No. That is the only stand.
No estoppel, no limitation against us.
Therefore, I fairly submitted nothing to say. What I suggest your lordship may direct, they will compare his mark and pass appropriate order. As your lordship please.
Yes, Mr. Mahapatra. How is the compare clear?
Yes. The only object, what you have stated, my lord, I know I have nothing to say. We have advertised in the paper and the advertisement what there, that if any mistake is there, you please approach within a particular time. That he has approached after 1 year, 9 months. That is the only ground we have taken.
But that will not take away his legal right.
No, I'm not at all telling, my lord. I know.
Yes.
I'm not at all telling.
Yes,
Very
Mr.
fair submitting. This is the only thing.
Without my fault, I'm continuing since 2017, your lordship. And more than 7 years, lordship. I'll cite some judgment.
I will cite to some recently I passed a judgment
And your
where I've said
I've got one.
that a person cannot take advantage of his own wrong. Number one.
That's not my fault.
You're not, I stand corrected, not that. Supposing you have been wrongly appointed. Now, may not be your fault, but you have been wrongly appointed. You do not deserve to be appointed, but somehow you have been appointed. So you have to make way. When the lots of decisions of this court and many such cases.
Yes.
And your lordship, one more. List of applied GRS candidate published for objective objection invite, your lordship. There, under in serial 139, the petition name, your lordship, where the residence certificate more than 6 months was applied, and that was the main reason for objection. That was also not taken care of, your lordship. That I need to file through my counter, your lordship. A residence certificate, the advertisement, it is very specific, your lordship. Lordship may peruse the advertisement which my learned friend has filed. That is page 18, your lordship.
I think what Mr. Mishra was suggesting initially appears to be more logical.
Yes.
I will send it back to the collector or whoever is the authority.
Yes.
Let him make a comparative assessment of all the
That
marks,
should be better. Yes.
quoting the admission in the counter.
Yes.
Let him take a decision.
Let him take a
And also, he will grant you an opportunity of hearing. So whatever you may have to say, you may say.
Your lordship, page 18, your lordship.
I will, but of what avail? Yes, go to.
Page 18, H, documents.
Residence certificate.
Residence certificate, bracketed, within 6 months of the last date of the application.
So he has not submitted that.
That's what the official document shows, your lordship.
Let him consider.
Exactly what I was suggesting, related subject to your lordship's acceptance, my lord. Let it go back to the collector. We will compare these 2 persons marks only. No,
not every. It will not be thrown open.
Yes, it will be confined to these 2, and you will pass, and these original marks will be taken into consideration, and the residence certificate objection will pass necessary order within a particular time. That will solve the purpose. Subject to your lordship.
Yes, the petitioner has approached this court with the following prayer. Stop. The brief facts relevant to decide the case are that an advertisement was issued by the DRDA Puri on 23/9/2017 inviting applications for engagement as multi-purpose assistants, bracketry, Gram Rozgar Sevaks.
GRS.
The petitioner and the opposite party number 5 were applicants along with others. A select list was select list na merit list select list select list. Where is that select list? You are just showing. देखना तो कोई
43, my lord.
Select list was published wherein the petitioner where is your petition? Your Pratibha Rautre, na kete?
Pratibha Rautre, serial number 18.
Yes, wherein the marks, plus 2 marks. Na?
This is plus 2 marks shown as 222, which is the
Wherein the plus 2 marks of the petitioner were shown as 222, and that of the opposite party number 6 was shown as 300,
390.
319. It is the case of the petitioner that she has actually secured 428 marks,
With annexure 10, here's the petition.
as would be evident from a copy of the CHSC certificate
Right.
and mark sheet enclosed as annexure 5 to the writ application. There is no dispute that the opposite party number 6 secured 319 marks in this said examination. Stop. However, because of such a clerical mistake, the opposite party number 6 was selected for appointment.
Sorry, 5 year old.
Sorry, opposite party number 5 was selected for appointment. Stop. Counter affidavit has been filed on behalf of opposite party numbers 3 and 4, wherein the clerical mistake has been aggravated in the following words.
Yes.
Paragraph 8 of court code.
पूरा कोड करते हो देखिए
है ना?
जो ऑब्जेक्शन टाइम टा भी लिखा है मैं डीपली ऑब्जेक्ट
In view of such admission, nothing further remains to be decided in the writ application. It is, however, submitted on behalf of opposite party number 5 that the petitioner's candidature could not have been considered even otherwise, as she had not submitted a proper resident certificate as required by the as required in the advertisement.
Yes, ma'am.
Yeah. Stop. After hearing learned counsel for the parties, this court is of the view that
Your Lordship has to set aside annexure 14.
yes.
Yeah. Right.
That a decision in this regard can be taken by the appropriate authority, that is opposite party number 3.
3. Project
Opposite
director.
party number 3.
Yes, ma'am.
After considering the typographical error, the clerical error in computation of the marks of the petitioner and opposite party number 5, as also the objection raised by opposite party number 5 relating to acceptance of the resident certificate of the petitioner. Stop. The writ application is therefore allowed. The impute order under annexure, the impute order the impute select list.
Reject High Court direction reject करचोंदी.
Impute order under annexure
14.
Sorry.
Page 62.
Is therefore set aside. The matter is remitted to the project director, DRDA Puri, bracket opposite party number 3, to consider the case afresh after taking into account the admission made in the counter affidavit referred above, as also the objection raised by the opposite party number 5 relating to resident certificate of the petitioner, by passing the reasoned order within 2 months from today. Stop. It is needless to mention that the opposite party number 3 shall grant opportunity of hearing to all necessary parties before passing the order, before passing the final order.
Right.
Yes.
Consider my tenure of
Yes, it is.
because without my fault.
Law now.
Your Lordship may say from the 2 months from the production of the certified
I
copy.
have said from today.
Today, as your Lordship. That will be better.
Item 24.
Item 24, my lord. The last occasion pointed out, I have filed one petition to impute Ms. Sumita Guruvili to as a party, OP number 5.
To include who?
Sumita Buluhuli. In fact, against her, I have no grievance because only my grievance against the opposite government.
No, it has already been allowed.
नहीं फाइल करछि सेरा लास्ट को माय लॉर्ड्स पॉइंटेड आउट शी इज नॉट ए पार्टी मु सबमिशन कर देली बट टू अवॉइड मल्टीप्लिसिटी आई हैव ओनली अदर एज पार्टी व्हाई आई एम सबमिटिंग ओनली
No, only allow it.
आगे
Allow it and you'll have to take notice.
सब्जेक्ट टू माय लॉर्ड्स एक्सेप्टेंस बट नोटिस दरकार नहीं काहे खाली ओनली वन पॉइंट आई एम इनवाइटिंग माय लॉर्ड्स काइंड एडमिशन दैट इज annexure पेज 55 annexure 8
Yes.
she was OP number 2.
Hmm.
She was belong to another Anganwadi center. I am belong to Handiputa Anganwadi center. By suppressing the material facts under Annexure 3, she was selected. She kindly Annexure 3.
Mr. Panda, it will be better if you take notice.
नहीं ठीक है सर खाली खाली कह गोटे मिनिट सेठी से अंगनवाड़ी केंद्र बाहर जहाँ she was selected तापरे I file appeal रे सब कलेक्टर होची होल्ड कले से मार्क शीट गुडा सब फैब्रिकेटेड मार्क शीट देगिरी she has been selected according to selection was satisfied. That order has not been challenged by her. Mu asisi seti subcollector passed the order and subcollector directed to verify my mark sheet. Under this order was passed. Thereafter new subcollector came and new subcollector made advertisement for fill up the post. Challenging the same I have come. Mu Sumita Bululi who was terminated tako year se more kichi nahi.
Then not press it. Not
No,
press.
she will be, if she will be ultimately affected.
Like she affected me. She is not challenging the same. ठीक है अगर मु से relevant portion टा देखो annexure 8 the lordship page 57 relevant portion page 58 page 57 my lords got it आगे 27/8/19 last the case is taken up today CDPO Thakurmunda in present in person
Is present.
in a person
No, he is present.
is present and submitted the photocopy of the letter number so and so dated Sashikanta so and so. The Board of Secondary Education Odisha Cuttack, learned advocate for the OP is also present. CDPO Thakurmunda is yet to submit the verification report in respect of documents submitted by the opposite party. Next, the case is taken up today. CDPO Thakurmunda is present and produced the original verification report furnished by Board of Secondary Education Odisha Cuttack by letter number so and so. Peruse the above letter. It reveals that.
No. You take notice.
ଆଜ୍ଞା ଟିକେ ସାରି ଦଉଛି ଖାଲି ଟିକେ
ମୁଁ ପଢି ସାରିଲିଣି ଆପଣ ସାରିବେ କଣ ମୁଁ ପଢି ସାରିଲିଣି
hence it is clear that Mrs. Sumita Bululi has got appointment of Anganwadi worker of Handiputa by producing fake certificate in Board of Secondary, hence disengage Sumita Bululi from the post of Anganwadi Handiputa Anganwadi Center and the CDPO is directed to depot some other Anganwadi worker to the nearest center to the in charge of so and so put up after verification receipt of verification report of the petitioners document more document it तापर आगे नुआ advertisement हे गला when this was pending नुआ subcollector आसिले and now advertisement has been made to fill up my response to submission Sumita Bululi who was disengaged she had produced fake certificate number 1 she belongs to another Anganwadi center and the subcollector rightly disengaged her. This order has not been challenged by Sumita Bululi. If she would have not been appointed, then I am the person who should have been given appointment because I had secured the highest mark and I belong to that area, my lord. Sumita Bululi is not affected by this order. She is not coming before this annual court. I am challenging the order of the government who has made fresh notification. So my respect to submission notice darkar nahi.
So if your writ application succeeds, what will it amount to? It will amount to quashment of the advertisement?
Second
advertisement? So the original thing or the order of the subcollector revives? Does it not? Does it not?
नहीं सबकलेक्टर ऑर्डर रहिला पर आगे फास्ट जोटा ताको डिसएंगेजमेंट कले एवं मोर मार्कशीट वेरीफाई कर मते देबे बिकॉज़ शी बिलोंग्स टू अनदर विलेज एंड बाय प्रैक्टिसिंग फ्रॉड शी हैज गॉट अपॉइंटमेंट.
Yes, you have filed your counter affidavit.
Yes.
In paragraph 16, we have stated, your lordship will kindly look to that. On perusal of the appeal, it is found towards the middle, sixth line, found that the appointment of Sunita Bululi is illegal since she has produced fake certificate indicating that
indicating she has secured the highest mark. Since Sunita Bulivali was disengaged, the sub-collector directed the CDPO present reponent to make a fresh advertisement. Because of the vacancy.
As per the advertisement under Annex 1, my lords, she must belong to that Anganwadi.
Yeah, that is all right. That is all right.
Again.
That has been taken care of.
Again, that is taken care of. So, in view of such,
All right, you do one thing. Just find out whether that person has filed any appeal challenging that order or not.
Yes.
Got it?
a stay order is there. Now, doctrine of legitimate expectation again move favor because I am the highest marks I have secured and she belongs to another Anganwadi worker. So my expectation that I should.
All right, all right.
Make allegations against her, then she has to be heard.
Learned State Council is directed to obtain instructions as to if Sunita कौन था ना?
Sumita Buliholi.
Sumita Bulivali.
Again.
BULIWILI.
Again.
Opposite party, my lord friend has impleaded her.
No, not implemented.
No, move petition to file.
Has preferred any appeal against the order passed by the sub-collector directing her disengagement. List this matter.
27 September.
27 September.
Item 25.
Item 25, I may be permitted to place on your Mr. Chair. Right here under Annexure 7, the order of the collector Malkangiri is under challenge wherein, my lord, the order of termination passed by your CEO, the CDPO has been confirmed. This Honorable Court issued notice on 7/21. It is awaiting counter to be filed by the state.
25. 25.
Filing.
Counter has been filed?
No, your lordships.
Yes. You'll file counter? Is it necessary?
Considering the prayer made for reinstatement.
Yes.
The counter would be necessary.
All right. Then State Council requests for some time to file counter. Is this matter?
27 September.
On 27 September.
I am obliged to lordships.
Item 26.
We have filed rejoinder today, my lord, and serving the copy to this today.
Land counsel for the petitioner files rejoinder in the court after serving copy on the other side. Is this matter?
20th September.
On 20th September.
Interim order.
Interim order to continue.
Item 27.
My lord, I am coming to this court to challenging the notification by the Annexure 1, my lord. 29/12/2023 was first advertisement by the subordinate staff selection commission, my lord. To ignoring this honorable court's direction to promotion as a Anganwadi supervisor, and who was eligible candidates who was continuing as the Anganwadi worker since 25 years, and they are the high qualification. But ignoring this, the authority to advertise the same on 29/12/2023. So we come to this honorable court with that, and previously this honorable court this honorable court also given direction to the Anganwadi workers to consider the collector, the authority to consider the same and promotion the as a Anganwadi supervisor as per qualification as well as.
Writ appeal, the instruction of 12th April 2024 is that there has been a writ appeal 366 of 2024, which has been filed by Srimati Ratnamani Mahanto.
Against the order of the coordinate bench?
And but yes.
Yes.
Against
so that is pending or that is still pending? Writ appeal must be pending.
So they must be pending. That of course the
so you
of
find out
2024.
They must be pending. Find out what has happened. If the writ appeal is pending, so how can we London State Council submits that writ appeal being WA number
WA number 366 of 2024.
366 of 2024 has been filed
By Ratnamani Mahanta
by one Ratnamani Mahanta against the
and batch.
Ratnamani Mahanta and batch against the order against the judgment passed by a coordinate bench
In WPC OSC.
in WPC
286 of
OSC number
2015.
286 of 2015 and batch. Yeah. It is further submitted that the writ appeal is pending. In such view of the matter, it would be better to await the result of the writ appeal. Let's this matter October karo.
25th October.
25th October.
My lord, in this case, my lord, this authority has also advertised exam will come.
You can file an
After notification.
all right, but since the writ
Exam
appeal,
will fix. If there will be appointment to.
so you appear in the writ appeal, file an appropriate application.
I know from this.
Yes.
My
So you
knowledge
file.
is other point.
Yes.
I will contest on that order. But the supervisor with the as per guideline, my lord, kindly see the guideline.
Sir, I cannot consider it now when the writ appeal is pending and this.
That in the notification is fresh appointment.
So you approach the writ appeal court.
Writ appeal court, I will appeal versus.
Yes. And you ask for stay of this notification. It has got a direct bearing. This court in the coordinate bench of this court held that yes, those Anganwadi workers who have rendered so much of service, they should also be engaged as supervisors instead of going for fresh advertisement.
Yes.
So that is directly an issue before the writ appeal. So you appear either by way of intervention application or whatever, file an application for stay. Yes.
But only I am coming this court to only challenge the notification.
I know. You are challenging your notification flows from that order.
In the meantime, if they to the intervention person, in the meantime they will be advertised and
Advertisement करो पड़ेगा कौन subject to result हमें कौन इतने व्यस्त कौन? Yes.
28.
28.
28.
No, item 28.
28, my lord, counter not filed, my lord. Yes, my lord.
Yes.
Last occasion, my lord, should
2 weeks time is allowed. 2 weeks further time is allowed to the state to file counter. Let's just matter.
28 September.
4 September.
The counter affidavit has been filed on
not so.
10th of
Where is that counter?
2024.
It is not there on record.
Oh, I'm sorry. I'm holding a wrong brief.
Very wrong brief.
28. No, that brief I don't have.
I'm granting you 2 weeks time. Yes.
Item 29.
It's in item 29, we have received the counter, my lords. 2 weeks time, I pray, madam, 2 weeks time.
2 weeks time is allowed to the petitioner to file rejoinder. Please this matter on 28th September.
Item 30.
On behalf of Budhiram Das.
20 next week.
Item 30.
All right. Please this matter next week as paid for.
Item 31.
Satik,
This is with regard to the selling the advertisement for the post of Jogana Society. And your lordships issue noticed.
Yes. 2 weeks time. Sir. 2 weeks time is granted to the state to file counter. Please this matter on
27th September.
27th September. Yes, thou. Me too. Please this matter 1 week after as paid for.
Item 33 only I'm subject to kindly direct to mediation.
You agree for mediation? He's suggesting for mediation.
I'm my brother is 32. I'm doing 33.
Oh, 33.
Yes.
33 key on the other side.
Lot is not appearing with the brother.
That is the key.
I am the petitioner.
Yes.
Who is the petitioner?
I am sir petitioner from Bhatchalpur, Bhadrak.
Yes.
Item 32 interim.
It's
a matrimonial dispute.
So here there is a suggestion for mediation.
No sir, mediation.
Mediation
So many matters are pending in Bhadrak, sir. The CP is pending at Jajpur court, sir. The divorce. CP is divorce for
No, no,
divorce.
no, that's all right. I'm not on merit. He is asking, he is saying that the matter can also be, I mean, amicably resolved between the parties through mediation.
ঠিক আছে, till that sir stay be allowed.
তারপর মিডিয়েশন বিষয়ে কিছু করোনা দেখে
স্যার সিপিটা সেটি স্যার হিয়ারিং হবে, এটি স্যার মিডিয়েশন হবে স্যার, সেটি প্রসিডিং চালিব স্যার, এটা অসুবিধা হবে না স্যার?
না না মিডিয়েশন হলে সিপিটা হিয়ারিং কোন হবে?
মিডিয়েশন যদি সিপিটা ঠিক আছে স্যার, ମୋ କହିବା କଥା ସ୍যার ଯଦି ସିପିଟା ସ୍যাର ମିଡିଏସନ ମାଧ୍ୟମରେ ଯିବା ପାଇଁ କହୁଛନ୍ତି କୋର୍ଟ।
ନାଇଁ ସାର୍ ଆପଣଙ୍କର ଡିସ୍ପ୍ୟୁଟ ରହିଲା ରିଗାର୍ଡିଂ ଦିସ୍ ଟ୍ରାନ୍ସଫର ପ୍ରଥମ କଥା, and if you may also the entire dispute may also be resolved, who knows? This is a matrimonial matter after all. So at any stage there can be a settlement between the parties. That is why
মিডিয়েশন শুড বি ডান স্যার। ভদ্রকর মিডিয়েশন হোক, ট্রান্সফরটা হয়ে যাবে ঠিক, এটি যদি হবো স্যার ভদ্রক
ট্রান্সফরটা এই যে মিডিয়েশন কোন হবে তাহলে?
এটি সোমেন কেসে স্যার পেন্ডিং ভদ্রক।
তারপরে সেটা চিন্তা করতুনি, সেটা মোটে চিন্তা করতুনি। The High Court will look after it, don't worry.
স্যার ডিভি সিআরপি জিআর কেস আর পেন্ডিং ভদ্রক কোর্ট। এইটি মিডিয়েশনটা এইটা ট্রান্সফরটা হয়ে গেছে
হবে না। All right, all right, we'll take it up. Let me come after recess, we'll take it up.
34 item is person concern already mediation success. 34.
No, I'm not saying.
some grounds have been taken on my part. Your Honor, Section 19 of Hindu Marriage Act. At the time of petition, filing of petition, when the marriage solemnized, when the respondent resides, and when the both parties were last time resided, these three factors are there. Three factors are in support of the petition. Sir, CP number 282/24 फाइल कला बेला जाजपुर कोर्ट रे मु भद्रक रे आज्ञा चाकरी करछि आज्ञा 2022 पाखरु भद्रक रे मु रहउछि आज्ञा बडा घरे मु रहउछि बाहागर मोर बाप घर हेतिला आज्ञा जामुपोसी आज्ञा सेटा जाजपुर जुरिडिक्शन भीतर आसु सर लास्ट रिसाइडर सर एठी आसुथले मो स्वामी मो गति भडा घरे आसुथले जाउथले एटा लास्ट रिसाइडर 7/7/23 पर्यंत मो गति से आसुथले 9/7/23 पर्यंत मो गति से आसुथले ये सर कथा या व्यतीत सर मु जुरिडिक्शन से आउ डीवी केस 354/24 सीआरपी 347/23 जीआर केस 2343/23 सब जुडिशन भद्रक सर अछि से मध्ये गोटे क्रिमिनल अपील करछन आज्ञा 18/24 से मध्ये भद्रक रे पेंडिंग अछि मु जने आज्ञा सर स्त्री लोक हेल्पलेस लेडी जस्ट डीओ डाटा एंट्री ऑपरेटर आउटसोर्सिंग रे 7,000 टका दरमा पाउछ भद्रक रे भडा घर नेक रहिछि से स्वामी आज्ञा बहुत रोजगार इन्फ्लुएंशियल पर्सन he has assaulted me several times on pretext of dowry and on allegation of false allegation of adultery sir mu विवाह समय रे मु डाटा एंट्री ऑपरेटर भाबरे जाजपुर रे चाकरी करथली आउटसोर्सिंग रे 21 मसिया सर ट्रांसफर हे गेला हमर केउझर को 22 मसिया सर मु आइली भद्रक सर भद्रक आसे से 21 मसिया फॉर द फर्स्ट टाइम पई ମତେ ସାର୍ ଆଲିଗେସନ କଲେ ମୁଁ ଏଡଲ୍ଟରୀ ଗୋଟେ ସଂଗ୍ରାମ ସାହୁ ବୋଲି ଗୋଟେ ଲୋକ ଅଫିସରେ ଚାକିରି କରିଛନ୍ତି ତାଙ୍କ ସହିତ ସେ କେନ୍ଦ୍ରାପଡ଼ା ଅଛନ୍ତି ଚାକିରି କରିଛନ୍ତି ମୁଁ ଭଦ୍ରକ ରହୁଛି ତାଙ୍କ ସହିତ ମୁଁ ଏଡଲ୍ଟରୀ ରହୁଛି ବୋଲି ଆଲିଗେସନ ଫର ଦ ଫାର୍ଷ୍ଟ ଟାଇମ 21 ମସିହା ସେ କଲେ
All right, yes, what do you say?
Right. I'm only suggesting this is the matrimonial proceeding. And the counsel for the petitioner submits that so many cases pending in Bhadrak, nowhere is he stated in the petition also. I have submitted my objection to that. Only I'm praying, there will be a mediation direction to the High Court Mediation Center. Trying to the.
No, he is not agreeable to
He's
the
not
mediation.
agree-
He is not agreeable. So I'll allow the transfers, grant you permission to appear through virtual mode. Usual order which is being passed.
Not necessary, because my lord, the petitioner is a working lady, not in destitute.
No, not this. I'm not asking for destitute.
No, my learned friend submits at that.
Who is accepting it?
Right.
The court is not giving a finding to
It's
that.
the DO in the government office, right? And the transferable job, whether assuming that the case is transferred from the Jaspur to Bhadrak. And now after 2 months or 6 months, again she is transferred to any other person.
Anyway, the law is that the convenience of the woman has to be given
But there is,
importance.
on the reason, some necessary ground must be there.
There is ground. There is ground. That he is residing at Bhadrak. That is a good enough ground. And
Because
so-
my lord, his father-in-law is residence on the jurisdiction of Jaspur, my lord.
I'm not considering that aspect.
Right.
I'm not considering the maintainability of the application on the ground of jurisdiction. It is simply a matter of convenience. I'm allowing it. You can appear through virtual mode whenever you want.
This allegation, FIR also lodged by the.
So that allegation was in
by
this
any
court.
other person.
No, this court, this court will not go into that question. Anyway, transfer application allowed. See you our virtual mode unless absolutely necessary. Physical appearance hobani. Yes.
Item 34.
34, I am also the.
With the petition, opposite party. Yes.
Here the mediation success.
Successful.
Court is there, my lord. And affidavit, joint affidavit also there. Mediation successful with the permanent alimony of 6,50,000.
So, no, this joint affidavit has been filed here.
Yes.
The parties are present.
Yes.
Was there any direction to the parties to appear?
Last occasion, because.
Acha. I will only record their contention with regard to the joint affidavit and I will relegate it to the court below so that can be disposed of in the court below.
Direction to the family court Bhubaneswar, so that they
Consider the joint affidavit there.
they have the permanent alimony, whatever the.
Whatever you have decided.
They will receive there and the decree of divorce will be passed.
Who are the parties? What is the signatory? Anuradha Mahapatra. Then Fire Kumar Ojha. Where is he?
Not necessary, I will take it. Because the direction has a physical appearance, and the reason my lord, she was trying to enter into the court, but due to non-accommodate by the council, she has not obtained the pass to entry. That is why your lordship directed to.
ଆପଣଙ୍କ ନାଁ ଅନୁରାଧା ମହାପାତ୍ର
Yes.
ଆପଣ କଣ ଆଇଡେଣ୍ଟିଟି କଣ ଆଣିଛନ୍ତି ଆଧାର କାର୍ଡ କି
His father and
କାଉନସିଲ କି
council. Some. ଆପଣଙ୍କ ଓକିଲ ସେଠି
ଆପଣଙ୍କ ଓକିଲ କାହାନ୍ତି as directed the petitioner Anuradha Mahapatra, who is a signatory to the joint affidavit, is present in the court. She files her Aadhaar card, original Aadhaar card, which is returned upon filing of a attested, signed Xerox copy thereof. Put a Xerox copy. Same be kept on record. The opposite party, Fire Kumar Ojha, is not present, but Sri Ramakanta Sahu, learned counsel, appearing for him, submits that his client has no objection. being a signatory to the joint affidavit. Stop. Since the parties have amicably resolved the dispute on the conditions mentioned in the joint affidavit, the transfer application is disposed of with a direction to the judge, family court, one or two.
CP 387/23.
किन जी तो को वन की टू कोई भी नहीं किन जानी यहाँ पर 4000 केस तंग पर 4000 केस जज फैमिली कोर्ट भुवनेश्वर dealing with CP number 387 of 2023 to pass necessary orders on a joint application being filed indicating the settlement on the terms and conditions already indicated in the joint affidavit filed before this court. I would joint affidavit city file kariye, so before appeal kariye.
Copy to the joint affidavit and mediation.
All right. The copy of the mediation report along with the joint affidavit be forwarded to the no, let it be forwarded by the court. Forwarded to the court below for doing the needful. Yes. The case before him shall be disposed of accordingly. Yes.
Within my time.
Within 4 weeks.
Fine. Keep going.
Item 35. Please, your lordship. This is an application for transfer of matrimonial proceedings from Kamakhya Nagar to Cuttack. In this case, mediation was directed.
Mediation
by
failed.
this honorable court, but mediation is failed. Mediation report is not there. I am filing.
No, it is there. It is there.
It is there.
It is there on the report. Mediation report indicates that the mediation between the parties has failed. The transfer application is therefore taken up for hearing on merits.
The opposite effect, my lord. Read for a 2-week time for filing of objection, my lord.
No, transfer application is allowed. You will be granted that opportunity of virtual hearing and all. Same.
Virtual court, my lord, आजकल बहुत problem होती.
कोई
साक्षी नबारे आउ आपनकर sensitization issue भी होची. Sensitization of family court होची. Virtual court साक्षी जरा हेले सब जिनसो पता को पड़ा.
किसी पता को सिंह. Virtual court only
as your lordship
court and the person concerned.
As your lordship
we have virtual courts. I mean, guaranteeing the confidentiality of the parties also. So that is why I am saying that he will be permitted to file a petition seeking permission, and that will be considered by the court below, depending on the circumstances. Yes.
Item
36.
May I please, Lordship? Lordship, here I am praying for transfer of the civil proceeding from Balesur to Puri. In the meantime, my lords, the opposite party has appeared and filed a counter affidavit, wherein, my lords, at para 9, Lordship. My learned senior is suggesting that it may be transferred to learned family court Cuttack. So I have taken instruction as far as Cuttack is concerned, we have no further.
The petitioner had filed this application seeking transfer of CP number 259 of 2023, filed by her husband opposite party in the court of Learned Judge, Family Court Balesur, to the court of Learned Judge, Family Court Puri. After appearance, the opposite party husband has filed a counter affidavit inter alia, stating that it would be convenient if the case is transferred to Cuttack instead of Puri. Learned counsel for the petitioner submits on instructions that he has no objection to the same, to the transfer as proposed by the opposite party. In such view of the matter, the transfer application is allowed. Cut off kar dena, hai na?
Obliged.
Item 37.
I am the petitioner. No, my husband. Marriage
Yes.
took place 2009 under the CP.
Yes.
CP number 282 is pending in the land court of family judge Jajpur. My prayer is to transfer from Jajpur family court to Bhadrak. My ground is that my husband is working at present as senior technician at Harichandanpur railway station, Keonjhar. Sir, Korei रहले हम ससुर घर मु कोरै रे मते ससुर रही कि मो झियटी हेतला 10 मसिया रे हेतला तापर से मते डोट कोन जात ना मु सेपरेशन हेछि मु दुनिया केस सर आगे भद्रक रे पेंडिंग अछि जीआर 984 बाय 13 सीआरपी 343 बाय 22 सीआरपी 113 बाय 24 114 बाय 24 321 बाय 24 सब आगे सब जुडिस आगे भद्रक रे आगे सर भद्रक होते मिडिल प्लेस से रहउछन आगे हरिचंदनपुर रे मु आगे मो मदर टेकिंग केयर भद्रक मो बुढ़ी माँ रहउछि मु आगे टीचरशिप कहउछि आगे से कोरे पाखा पाखी उटे टीचरशिप कहउछि आगे भद्रक सर कन्वीनिएंट फॉर बोथ द पार्टीज मैं कैन बी पिटिशन बी अलाउड टू ट्रांसफर द सीपी नंबर 282 फ्रॉम लैंड कोर्ट ऑफ जाजपुर to Bhadrak, Your Honor.
Any chance of settlement between the parties? Settlement of the dispute?
No, sir, no chance, sir.
You are not agreeing to any suggestion? In every case, you are refusing for mediation. Have you taken instruction from your client?
Yes, sir.
When did you take instruction, sir?
More than 1 year.
More than 1 year you have taken instruction. When did you file this case?
ये 23 मसिया सर
23 में सर अपने इंस्ट्रक्शन नहीं की फाइल करते थे देयर विल बी नो सेटलमेंट
अन्य केस सर सीआरपी डीबी सब दुनिया केस पेंडिंग
नो यू टेक फर्दर इंस्ट्रक्शन
My lord, the petitioner, he is serving at Korei. He is a government servant, teacher. Her daughter is reading in class 8 at Korei High School, staying at Korei. From Korei to Jaspur town, 15 kilometer distance. From Korei to Bhadrak, 50 kilometer distance, my lord. And under RTI, the petition, the opposite party obtain information, present information. At present, the petitioner is serving under BO Korei, my lord. There it is convenient for both the parties. The Jaspur should be the proper place for adjudication of the matter.
Sir, though I am working as a teacher at Korei, it is a contractual teacher. Now I have been permanent.
Not contractual.
But my husband is working at Harichandanpur PS. I am the advocate of the petitioner. I am relaxing her. On part of the petitioner, it is quite impossible to conduct the case and pay her advocate. I am relaxed. I am giving relaxation. And when she will get her maintenance, he is giving payment to me. কিন্তু sir Jajpur se court कुकल सा करी परी मते sir मु जो relax दउची से relax से दे पारिबन sir मु एटी चलौची sir से तार instruction चलै पाउची जाजपुर से चलै पारिबन sir मु बिना एते पैसा से एते बाट मु जाई पारिबनी sir गुटे दिन डिटेन कन भद्रक sir जाजपुर जाई पारिबनी sir relaxation देई पारिबनी एक अछि sir mediation भद्रक हला sir middle bus से sir हरिचंद्र पर चाकरी करछन sir 1 लाख एबो दरमा पाउछन sir भद्रक के मिडिल बस तापर सो मेन केसेस आर पेंडिंग हियर सर पेंडिंग हियर सो मेन केसेस
all right
I have filed an objection.
The transfer application has been filed by the petitioner wife seeking transfer of CP case number 282 of 2023 from the court of learned judge family court Jajpur to the court of learned judge family court Bhadrak. Therefore transfer has been made on the ground that the petitioner is though serving at Korei, yet several cases between the parties are presently pending before different courts at Bhadrak, and further the are pending at Bhadrak. An objection has been filed on behalf of the opposite party. Have you served copy?
Well,
Chale eटा गुना It's okay.
Date may be urgent so that
Ichi darkar nahi. Learned counsel for the opposite party husband has opposed the prayer for transfer by submitting that he is working at Harichandanpur in the district of Keonjhar, and that the distance between Korei and Jajpur is only 15 kilometers, whereas 15 kilometers, out of Besio actually, 15 kilometers, whereas the distance between Korei and Bhadrak would be more than 50 kilometers. As such, it would be more convenient if the case is taken up if the case is allowed to continue at Jajpur than at Bhadrak. Stop. There is no dispute. It is admitted that the petitioner is working as a teacher in Korei.
Manchuria Maktab Primary School.
She is admitted. She has admitted it.
Para 3.
It is also admitted that her husband is working at Harichandanpur in the district of Keonjhar. So, therefore, considering the convenience of both parties, this court is of the considered view that it would be better if the case is allowed to continue at Jajpur instead of being transferred to Bhadrak. In such view of the matter, this court is not inclined to allow the prayer for transfer. The transfer application is therefore dismissed. Yes.
38.
Please, your lordship. I am from transfer Baleshwar to Bhubaneswar, Malas. But only 2-3 grounds, madam. I am the 4-year-old child, Malas. And Malas, nobody is look after. And Malas, the two cases from the 125 CRPC as well as the domestic.
For the other side.
Your Lordship, for the opposite party on behalf of Ms. B. Mishra.
Any chance of settlement?
I'm praying for an adjournment for the next week, Your Lordship.
Next week she wants?
Next week, yes.
Next week. Next week as per.
Settlement ke to habani, sir. I'm bossy thilu.
No,
Lordship, carry it.
Yes.
Next week?
Yes.
Item 39.
Then I am filing this case for fixation of a time limit to comply the order of appellate authority.
You have filed a petition for? Who are you?
I am for the opposite party number 5, my lord. The appellate order of appellate authority order was challenged by the managing committee and another is Swagat Kumar Sahu, who is continuing in my post. Will also dismiss the writ petition, but there is no time limit to comply the order of appellate authority.
No, what was the order? Have you served copy on the other side? On Mr. Ratha?
Perhaps on the last occasion, my Lord Senior Mr. Ratha had taken a time for filing objection.
What was the judgment?
The judgment, your lordship dismissed the writ petition and directed to the Commissioner cum Secretary to adjust the petition. I am for the opposite party number 5.
The opposite party number 5. Let me see the final order.
Since he has continued 17 years above, he was directed to adjust. The managing committee is not allowing the petitioner, opposite party number 5 to join.
So, opposite party number 5 means Swagat Kumar Sahu?
No.
Oh?
Pramod Nanda. Swagat Sahu petitioner thile. He challenge karthile. Managing committee challenge karthile. Dita kar.
Swagat Kumar Sahu's appointment was held to be illegal. In spite of that.
Illegal koi nahi. Direction hela Commissioner cum Secretary.
No, that would adjust him in any other school. In any available vacancy, either in the same school or any other school, purely on humanitarian consideration. And you are the petitioner.
So, opposite party number 5.
So what is your name?
Order of appellate authority was challenged by the managing committee and Swagat Sahu, which is continuing in my post.
Yes.
So, appellate regional director directing reinstatement of the opposite party number 5.
Yes.
Pramod Kumar Nanda.
Yes. Then
the petition was dismissed by your lordship, filed by the managing committee and from Swagat Kumar Sahu.
No, I find a little bit some confusion here. Yes, Mr. Das? It seems to be confusing. You were the opposite party number 5, isn't it?
In this case, my lord, we are appealing for the petitioner. We have no instruction, ma'am.
So what was the order of the joint director?
The Joint Director on dated
It is 11/2010.
again.
What was the order?
Directing the opposite party reinstatement of the petitioner means Pramod Kumar Nanda.
So
I'm for the appellant before the.
so this court rejected. This court rejected. It means that order of the joint director was stands. Whereby he was required to be reinstated. So now, how are you affected? You are the same person, Pramod Nanda. Join kira do not. The control file could not. Appropriate order.
Time fixing.
What time fixing?
Appellate authority order ta comply kariya pai time fix he. Takor ita dismiss he gala kintu time fix kala.
How can that order be passed? Can it be passed in this disposed of application?
Since it has been disposed of, what?
No, I don't think so. You could have filed another writ application praying for that direction.
Referring to the.
And you are not the petitioner, you are the opposite party number 5. But one thing, the order, he is affected by the order.
Then he has to.
You have to file another writ application. Simply, writ application for a direction will do probably, isn't it? You examine the matter again. Ask your senior, let him just. Compliance by miscase can be compliance to have.
Dismiss hela ta.
Dismiss hela. Challenge go through writ. Dismiss hela. It is for them to either challenge it in higher forum or what. So the order of the you need a positive direction from this court to implement the order of the joint director. For that you have to file a writ application. You cannot seek that relief in this disposal of writ application, not filed by you, but filed by somebody else. Yes. I'll reject it. IA. It's open to you. IA 6038 of 2024. This is an application filed by the opposite party number 5, seeking a direction. Opposite party number 5 to fix a time limit for time limit to ensure implementation of the judgment of this court by allowing opposite party number 5 to join in his former post in the school. This court finds that the writ application was filed by the petitioners challenging the order passed by the joint director, directing reinstatement of the present petitioner. That writ application was dismissed. The petitioner was opposite. Petitioner is the opposite party number 5 in the said writ application. Once the writ application has been dismissed, it is obvious that the order impugned stands. Insofar as implementation of that of the said order is concerned, no direction can be issued in the disposed of writ application filed by other parties. If the petitioner feels aggrieved, he can seek appropriate legal remedy for implementation of the order. The IA is therefore dismissed.
Item 40. You have to Mr. Reinstatement, I may be permitted to estimate. With 10 years conviction for the offense under section 376(2)(n) and 376(2)(i) in section 6 of the POCSO Act.
313 is.
And 313. My lord, here is the case, my lord. The appellant, my lord, custody since 2015. And your lordship granted interim bail twice. And I am surrendered, my lord, in time. On that ground, my lord, your lordship,
Yes.
Twice he has availed interim bail, my lord, on 4 months and 3 months. And
How
so
come?
far as
never misutilize the liberty.
ଆଉ ଦିଥର ଖଣ୍ଡେ ଦିଆହେଲା ଇଣ୍ଟରିମ୍ ବେଲ୍ ଦିଆହେଲା ଆଉ କେତେ ଦିଆଯିବ
ବର୍ଷ ରହିଲାଣି।
କନଭିକ୍ସନ ହେଇଛି ଆଉ
PW1 victim and
How much?
PW10 doctor
People
here
are already-
also.
ଆଉ ସେମିତି କଣ ଚାଲିଥିବ ମିଷ୍ଟର ସାହୁ କେମିତି ଚାଲିଥିବ କି ଭିତରକୁ ଯାଉଥିବ ପୁଣି ବାହାର କରୁଥିବ ପୁଣି ଭିତରକୁ ଯାଉଥିବ ସେମିତି ହେଲେ କେମିତି ହବ ଏଇଟା କନଭିକ୍ସନ ପରେ କ୍ରିମିନାଲ ଆପିଲଟା କନଭିକ୍ସନ ହେଇଛି and there is evidence against him.
Yes.
There is
Handicap person.
ହ୍ୟାଣ୍ଡିକ୍ୟାପ୍ ଯାହା କରିଛି ଆଉ ହ୍ୟାଣ୍ଡିକ୍ୟାପ୍ ହବନି ଫର
2 ମାସ ଖଣ୍ଡେ ଯାଉ।
ନାଇଁ ହବନି
ଠିକ ଅଛି।
ହବନି ହବନି This is an application IU 1792 for 2000 an application for bail filed by the convict appellant on the ground of delay in disposal of the appeal. Stop. Considering the above ground, the petitioner was earlier granted interim bail on 2 occasions. Since there is overwhelming evidence against the petitioner, and since there is overwhelming evidence against the petitioner for which he was convicted, I am not inclined to allow the prayer for bail at this stage. More so as he was granted interim bail not very long ago. The bail application therefore stands rejected. आप किसी दिन जाओ फाइल करिए देखिए इसमें कहली at this stage. Yes.
Item 41.
The extension of time.
May I please, your lordship, permitted to withdraw.
What permit to be?
Permitted to withdraw.
Which one?
Petitioner Hemasagar Marai.
What will you withdraw? It has already been disposed of. Disposed of with the direction to the court below to dispose of within 6 months time is allowed to the court below for disposal of the case.
Item 42.
Yes. 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 कौन इसे इतने?
Interim bail application. The flag U.
Flag O.
Flag U.
Flag E.
He was granted interim bail for a period of 4 months for heart surgery.
Yes. Then
Due to the other parameters are high and financial difficulties, it has not been done and he surrendered in before expiry. Now I have prayed for fresh interim application.
flag कितने कहले? Flag कितने?
Again,
Flag कितने?
flag U. 963.
Yes.
963 flag U.
Okay.
Lordships may give me 2 minutes time.
Yes.
Lordship may pass any order, but your lordships on 28/5/2024,
Yes.
the wife had filed an IA for releasing on interim bail because the wife is also an accused. The wife said that some money is required, therefore I may be released on interim bail. Now, at the time of the surrender, the wife has taken another ground that my uterus needs to be removal and she doesn't speak about the money part. On that pretext, a petition is pending. That means as far as the money is concerned, it has already been arranged and organized. And as far as this accused is concerned, your lordships had released him on interim bail on 13/3/2024. But your lordships till 2/5/2024, he did not take any step. He was sitting at home. Only for the first time after 2 months, he went to the hospital and asking for the treatment, your lordships. Therefore, your lordships, he may clearly and categorically tell that how much money is required, where he needs to be, because again, he will, your lordships, come and ask for extension. Which hospital, how much money is required, what is the date of the treatment, what is the itinerary, who is the doctor.
But you can roughly indicate the time of surgery.
He's right.
ଦେଇଛି ନା estimate ବି ଦେଇଛି କେତେ estimates ସେମାନେ ମାଗିଛନ୍ତି ଆଜ୍ଞା
କୋଉଥିରେ ଅଛି କେତେ?
ଏଇଥିରେ ଆଜ୍ଞା ଦେଇଥିଲି that
Because wife was released on interim bail under the pretext that I need some money. At the extent,
page coded.
wife ଯେତେବେଳେ extension move କଲେ, wife is asking about uterus removal, not speaking about money. That means it will be presumed that the money has been organized, your lordships.
No, but when is the surgery likely to take place?
ସେଟା ତ ତାର other parameter ବି ଦେଇଛି ସବୁ ତ medical report.
I don't know. I'm asking.
Diabetic checkup ଚାଲିଛି. The Lords may grant 3 months time, I think so. If will not be done, then that is his own risk because I don't want to
I will grant him 1 month time.
ହଁ ଯଦି ଅଗର ମାସେ ଭିତରେ
1 month ଭିତରେ ଯଦି ସେ
ଯଦି ହେଲା ଯଦି ଦରକାର ପଡିଲା I will come for extension.
that is one. If you can show the convince the court.
I am fully agree with the Lords. But since considering
All right, I'm allowing him for 1 month.
Yes, your lordships.
This is an application. 963 of 2024. This is an application for interim bail filed by the petitioner on the ground of his treatment in the form of surgery. In this form of cardiac surgery, certain medical documents have been enclosed to the IA along with an estimate of the cost of such treatment and surgery furnished by the given by the hospital. Stop. It is submitted that the petitioner was earlier released on interim bail as per order passed by this court, but he could not undergo surgery because of various reasons, including कौन भाई surgery ही पहला नहीं
diabetic high diabetic
for various reasons, including his diabetic condition, which did not permit surgery. Stop. Para. Sri Sarthak Naik, learned counsel appearing for the CBI, has opposed the prayer for interim bail on the ground that the a definite timeline has not been given in the IA as to when the surgery is definitely will definitely take place. And secondly,
from 23/2024 to 22/5/2024, your lordships, he kept quiet. He did not go to doctor.
And further, on the last occasion, despite being granted interim bail, no steps were apparently taken by the petitioner to arrange the necessary finances. Having heard the counsel for the parties and upon perusal of the medical documents enclosed to the IA, this court is inclined to take a lenient view, having regard to the physical ailment of the petitioner. The IA is allowed. Let the petitioner be released on interim bail for a period of 1 month, such and such. Yes.
Item 43.
So a free copy of the order may be provided.
Free copy of this order be handed over to Sri Sarthak Naik, Learned counsel for the CBI.
May I let's say I filed an IA for on behalf of Mr. Sahu, let's say. Let's say I filed an IA for
modification.
Yes, Lord.
What modification?
Lordship, and see para 9(1), your lordship. There is a term, your lordship. They shall appear personally before the Begunia police station on every alternative day, your lordship. Lordship, similar order has your lordship. Another co-accused, your lordship.
ये कर दो ना.
Okay. One line, lordship. They were directed to appear the trial court on each date of posting. Whatever in the present scenario, lordship, the accused persons who have allowed on bail.
Wait. Yes, sir. Wait. Your matter is going on.
In the meantime, lordship, they have arranged some people, and now the purpose to the opposite party with the case, lordship. The family members has now they have excommunicated that they worry.
excommunicated तो
exact wording
कौन ही
ତାକୁ ବହିଷ୍କାର କରିକି ରଖ
voice करते excommunicate और कौन
excommunicate ଆଉ ଗୋଟେ appropriate wording ostracized
ostracized माने stigmatized excommunicating माने excommunicating removing somebody from the society if you want you can file a petition for cancellation of bail that will be considered ଆଉ ଏଇଠି କହିଲେ କଣଟା ହବ
the same may be considered by the law of trial
no 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 ସେଥିରେ ତାଙ୍କ petition ଆପଣଙ୍କ ପାଇଁ ଅର୍ଡର ହେଇପାରିବନି ହବନି
well file
ଆପଣ ଫାଇଲ କରନ୍ତି ଆପଣ ଫାଇଲ କରିବେ that will be considered ଆଉ କଣ yes item 44
The matter become infructuous.
yes yes
Infructuous matter.
infructuous yes
ଆମ ନାଁଟା ଉଠୁନି ଆମେ କ୍ଲିୟର କରୁଛୁ
how did you say then modification of order
ABLPL 14.
yes Mr. Sorangi modification
sir
what modification you want
lordship there was a composite FIR against 9 persons while considering the bail application of lordship except me all others are go and release on surrendering the on finding that the allegations are against me only this Lakshmidhar corridor then I came before your lordship in a modification your lordship said because I submitted that all other persons have gone my lord had granted on 26/7 further the court below shall follow the principle of parity since it is submitted that several co-accused persons have been released on bail
yes
but I in fact appeared but the learned magistrate was not very inclined that since the High Court did not give bail so I withdrew the petition so I am not filing that but that is the I tried to move it my lord so now the question I have raised my lord in the charge sheet that has been filed
it has already been disposed of how reopen kariyo bole
lordship may grant me liberty to refile
an anticipatory bail application
my lord
no that liberty cannot be pressed no not press kar diyo it is open to you not that cannot be you sought for modification I modified it now the court below is not inclined kuch kariyo bole nothing can be done about it once an order has been passed rightly wrongly whatever an order has been
that
passed
I am not on the merit of that now if your lordship would permit me I will place only the
no whatever I cannot pass any order now I cannot recall that order
at least also can say that I am not pressing that application as regards to him, as regards to the present petitioner. So that some gives up some leeway if I can come back. Because in any case, opposite party informant is here.
No. This is between you and the court.
No, he is against me.
He may be against you. He has to be against you. That is not an issue.
It is a general allegation against all. Not that I was holding any weapon. No doubt injury has been made, suffered and there is a grievous one also.
So I granted first or second hour.
नहीं अपन first time grant करथिले
oh to surrender before the court below and it will be considered on its own merit no on its own merit for you
नहीं मो पे थिला on merit नहीं अपन कहले jointly assaulted the injured however the allegation of assault is specifically against the Lakshmidhar corridor it is not correct I can demonstrate but that lordship may not go there having regard to the nature of acquisition and the matters I am not inclined to grant anticipatory bail to the petitioners the ABL appeal is however disposed of granting liberty to the petitioners to surrender before the court below within 2 weeks and certified copy of the surrender move for bail in such event they shall be released on bail by such and such this was the observation
that was the observation in respect of others
in respect of naturally my lord others so after they went in bail I came for modification your lordship was kind enough to say that further this court observes that the parity will be observed I appeared but he said that okay this is the what I submitted my lord that how can I give once the High Court is refused so I am here with the charge sheet also if your lordship would look at page 14
he can grant bail there is no problem in granting bail High Court has not refused High Court has refused anticipatory bail it's not a regular bail it's not a question of regular
it is the observation and I didn't wait until she passes an order and sends me to jail your lordship I withdrew the petition
no kichu kariyo bole kichu kariyo rightly wrongly I passed an order I modified it how further modification come
because this was not the contingency then I thought that that will possibly suffice my client's interest
no
your lordship may observe that the anticipatory bail was refused
anticipatory bail was refused
my lord
how will it help you
I don't know
it will not help you at all
I don't know.
I will not pass that order. Nothing can be done now.
One
Yes.
thing I was thinking, let me think aloud also, that if your lordship allows me to withdraw the ABLAPL, maybe I can book a place. And then with all materials I will come, your lordship, with giving that certificate, maybe
No, once it has been disposed of,
disposed.
again modified. At this stage, you will withdraw it. How can it be? You can withdraw your IA.
I can anytime withdraw.
No.
Liberty cannot be granted.
How can the liberty be granted? He has to go inside. If it is rejected, he has to go inside.
Let it lie over. I will
All
take
right, all right.
interest.
All right. Let's just matter next week as per. Next week. Yes.
45.
I prefer interim bail application, my lord. Custody since 3/5/21, my lord. Nishamukti Kendra, owner of the present petitioner is the owner of the Nishamukti Kendra. One person died, my lord. And 9 witnesses yet to be examined. 20 witnesses have already been examined. The mother of the petitioner is ill, my lord, and suffering from pelvis fracture, my lord. And
Have those two persons been examined? Subandhu Kanta Das and Ranjit Kumar Lenka?
my lord, they have already been.
They are reported.
No, one I think
dead,
my lord, and
Ranjit Lenga dead, my lord.
Ranjit Lenka is dead. Okay.
My lord.
On what ground do you want interim bail?
Mother of the petitioner.
Yeah. Swelling in hip, pain in hip. Yeah.
Only son, my lord.
No. I have already granted you interim bail once.
For a fortnight, your lord.
This is a heinous crime, heinous offense.
the inmates, they have
I remember the case.
seen the incident, my lord. So
I remember the
they are
case, Mr. Manthi.
My lord. I prefer interim bail for a period of 15 days.
No.
Earlier, my lord, I also surrender in the meantime, my lord. Only son, my lord.
All right, prayer for interim bail has been made on the ground of illness of the petitioner's mother. It is submitted, several medical documents have been enclosed to the IA. Considering the submissions and the grounds on which the prayer for interim bail is made, I am inclined to take a lenient view. Let the petitioner be released on interim bail for a period of 10 days.
Published.
Item 46. Disposed of.
IA is disposed of.
IA disposed.
Lord, here, my lord, earlier bail application of the present petitioner was disposed of by this honorable court, my lord, thrice. Your lordship was pleased to reject my bail applications, my lord, and in IA, your lordship was pleased to release me on bail some period, and then in time, my lord, this present petitioner surrender, and my lord, he is inside the custody. Here, my lord, petitioner before your lordship is the husband, and my lord, if your lordship will kind of have a glance to this, the rejection order, paragraph, my lord, page 14, my lord. Rejection order, my
But I rejected it on merit.
Merit thereafter some changes are subsequently changes.
changes?
Out of 37 charge sheet witnesses, 15 witnesses has already been examined.
17.
And, 17. And in para 4, that the Lawrence court below was pleased to record that peruse the case record. It reveals that out of 37 charge sheet witnesses, 15 witnesses have already been examined, though PW 1 to 14. They did not supported the prosecution case. Only PW 15, who is the paternal uncle of the deceased, supported the case of the prosecution and stated that so and so a demand kotha khali se kauchi. Thereafter, my lord, and at present, my lord, the court is totally that the PO is not there at the station. For that reason, my lord, no development, nothing. I'm in custody. And my lord, since 2021, I'm in custody, my lord.
15, 16, and 17. 3 of them supported the prosecution.
Yeah, that's it. Last occasion, your lordship.
1 year of marriage.
I interim application to go some days, my lord, because the PO is on that court is not functioning on that ground. So that is my humble submission. that my lord, these are the subsequent development and PO is not at all there at the
କୋଉ କୋର୍ଟ କୋଉ ଜାଗାର
କେନ୍ଦ୍ରାପଡ଼ା ଆଜ୍ଞା trial court
ଏଟିଜେ
ଆଜ୍ଞା court ନା
I am for the
ତେଣୁ ମୁଁ ହାବିଚୁଆଲ ଅଫେଣ୍ଡର ନୁହଁ ମୁଁ ବି ଆଜ୍ଞା ମତେ ଯୋଉ ଯେତିକି ଦିନ ଦେଇଥିଲେ ମୁଁ ବି ଆସିକି ସରେଣ୍ଡର କରିଛି ଆଉ 37ଟା ସାକ୍ଷୀରୁ ବର୍ତ୍ତମାନ 15-17 ଜଣ ଗଲେଣି 14 ଜଣ କେହି ସପୋର୍ଟ କରିନାହାନ୍ତି
ବାକି ମାନେ କଲେଣି
ଆଜ୍ଞା
ବାକି 3 ଜଣ କରିସାରିଲେଣି ମିଷ୍ଟର ସାହୁ
ଆଜ୍ଞା
ରିଜେକ୍ଟେଡ
ଇଣ୍ଟରିମ୍ ବେଲ୍ ଫାଇଲ କରି
ରିଜେକ୍ଟେଡ
ନାଇଁ ମୁଁ ମତେ କହିଥିଲେ ଇଣ୍ଟରିମ୍ ବେଲ୍ ଫାଇଲ କରିବା ପାଇଁ
ମୁଁ କହିଥିଲି
ହଁ ହଁ ଆଜ୍ଞା କହିଥିଲେ ନା ନା ମୁଁ ମିଛ କହୁନି ସଜେଷ୍ଟେଡ ମତେ ସଜେଷ୍ଟ କରିଥିଲେ ଆଉ ମୁଁ ଟିକେ ଅଧିକା ଲୋଭ ହେଇଗଲା ଆଉ କାଳେ ହେଇଯିବ କି ଡାଇରେକ୍ଟ
ମେରିଟରେ
ଏଇଆ ହଉଛି
Where is that IE?
I not filed.
ମୁଁ ଆଜ୍ଞା କରିପାରୁନି
IE ଫାଇଲ କରୁନ
ଆଜ୍ଞା
IE ଫାଇଲ କରୁନ
Last revision.
if I had suggested then you should have filed that IE.
ନେକ୍ସଟ ୱିକରେ ଆଜ୍ଞା ମୁଁ କରିଦେବି ସିଗ୍ନେଚର ଧରିକି
This matter next week.
ନେକ୍ସଟ ୱିକ ଆଜ୍ଞା
Item 47.
ପବ୍ଲିଶ କରୁଛି
Can you take it up next week? Let's see.
All right, next week.
Item 48.
May I please, my lords. With the second round to litigation, my lord. Earlier, my lord, the bail application petitioner interim bail was granted for a period of, my lord,
3 months.
3 months.
Recently has been released, my lord. After rejection.
My lord. So far the merit is concerned, my lord. This
The victim has completely stated supported
Yes.
the prosecution.
164 is there. Medical
My lord.
is there.
I draw your lordship's attention only to lordship permission, my lord, that the petitioner, same petitioner, my lord.
13-year-old girl.
हाँ मुझे सकता हूँ annexure 4 my lord series my lord I have filed the lordship kindly have a glance that the this present petitioner the informant mother is the informant same my lord victim girl lodged in the affair just to 1 year before to against my mom uncle same offense same allegation which was my lord I filed the judgment my lord which was ended trial ended
ତା ସହିତ ୟାର ସମ୍ପର୍କ କଣ?
କାରଣ ସେ ବା ଏଇ କଥା ନେଇକି ପଇସା ନେଇ କମ୍ପ୍ରମାଇଜ ଆମ କଥା ବି ସେୟା କରିବେ ଲର୍ଡସିପ କାଇଣ୍ଡଲି have a glass judgment I filed ଲର୍ଡସିପ ଗ୍ଲାସ ଫାଇଲ କରିଛି ଆଉ
ନାଇଁ ସେ ମୁଁ ଥରେ ରିଜେକ୍ଟ କରିସାରିଛି ଆଉ ଦେଖି
ମୁଁ 37 ରେ ଫାଇଲ କରିଛି ସେମାନେ ମୋ ମାମୁଁ ଘରେ କଲେ ଗତ ବର୍ଷ ମିଳିଲା that pay the trial acquittal on the ground by lord the lordship କାଳେ grants judgment
ମିଷ୍ଟର ଦାସ
victim ଆଉ informant ସେ କଣ କଲେ କି ସେ କହିଲେ ଆମେ prosecution କୁ ଷ୍ଟାଣ୍ଡ କଲେ ପଇସା ନେଲେ କମ୍ପ୍ରମାଇଜ କଲେ that well ପୁଣି again your ଭଣଜା petition କଲେ ମିଳିଲା this is the same allegation say 376
Victim has vividly described over the occurrence which prima facie shows complicity of the petitioner. This is in this case. We cannot say that in the other case, since in the other case was falsely filed according to you, this case is also false. How can this court hold that? How can this court presume that this case is a false case?
and ମୁଁ ଟିକେ ସେ ଯୋଉ vividly କହିଛନ୍ତି ସେଟା ଦେଖିବି ଟିକେ ତାହେଲେ first time it has come millet after filing the bail application
Leave this matter next week as paid for.
ଆଜ୍ଞା
Item 49.
ଠିକ ଅଛି
May I please? On behalf of the system, I'm happy. So, offense under section 21B, 29 of the NDPS Act, on the basis of the consent statement of the co-accused person, the petition has been implemented in this case. In the meantime, a similar situation person, one Anil Kumar Das has been released by this honorable court.
13 gram not from his possession. It has been seized from
Same order.
Govinda Jena.
All right, same order.
Item 50.
my lord
Well, in this case, case and counter case. Case and counter case. In case counter case and in this case, all the accused person released on bail, petitioner is old and infirm persons, not a specific allegation against it. My resolution on parity basis we release on bail.
Earlier rejected probably?
Earlier
Rejected, my lord suggested, let it be lie over there. File extension in that case.
The previous.
extension भी फाइल करती है ना
with a आसची ए बिल
कोते कौन हिच
14577 out
145 से तो नहीं
अच्छा मैंने
अभी तो 145 से ऑर्डर रिकॉर्ड था ना सेटा स्कैनिंग
सर्टिफिकेट कॉपी अच्छी था
अच्छी था
ସେଇ କେସ୍ ରେ
First of
ପାରା 5 ରେ ହେଇଛି the aforesaid case in the first hour and to move for bail in case of a rejection. Therefore, they shall be liberty to move the higher forum for bail in the second hour, which shall be disposed on the same day.
ସେଇଟାକୁ ଏକ୍ସଟେନସନ କରିବା ପାଇଁ ଗୋଟେ ଆଇଏଫ୍ ଫାଇଲ କରିବା
ନା
ପାଇଁ
ଏକ୍ସଟେନସନ ମଡିଫାଇ ଫାଇଲ କରିଛି ମୁଁ ପ୍ରେଜେଣ୍ଟ ପିଟିସନ ଫାଇଲ କରିଛି
Present petition ଛାଡ଼ନ୍ତୁ ସେଇ କେସରେ ଆପଣ ଅଲରେଡି ଆସିଥିଲେ this order you have got.
ହଁ
Correct? So now
ଚେଞ୍ଜିଂ ସର୍କମସ୍ଟାନ୍ସ ସମସ୍ତେ ପଢିଲେଣି ବେଲେ
ନାଇଁ ସେଟା ହବନି ଆପଣଙ୍କୁ ଖାଲି ଦିଟା ଏଇ କେସଟାକୁ ମଡିଫାଇ କରିଦବା granting you extension of time and direction to the court to apply the principle of parity. That will do. I 1612 of 2023
ପ୍ରେଜେଣ୍ଟ କେସଟା ୱିଥଡ୍ର ହବ
ସେଟା withdraw ହବ. Considering the submissions, the prayer for modification of order dated 13/2/2024 is allowed to the extent of adding the following sentence after following sentence in paragraph and at the end of paragraph 5. Further, the courts below shall apply the principle of parity since it is submitted that all other co-accused persons have in the meantime been released on bail.
alleged counter FIR ମଧ୍ୟ ସମସ୍ତେ ରିଲିଜ ହେଇଛି
ତାପରେ ଲେଖନ୍ତୁ 2 weeks time is allowed to the petitioner to surrender in terms of the order dated 13/2/2024. এটা আমরা agree করব ଆଉ modification টা সেটা হলো এটা 2 weeks time extra allow হলো. Yes.
ABL APL 4340
dismissed as not pressed.
ଆଉ during concession bail counter FIR ମଧ୍ୟ ସମସ୍ତେ ରିଲିଜ ହେଇଛି
ନାଇଁ ଲେଖିଲେ all other co-accused persons have been released on bail ହେଲାନି ସମସ୍ତେ ହେଲେ ଆଉ.
Item 51.
May I please worship? My lord, offense under section 20A of NDPS Act and 27I of Odisha Forest Act, my lord. The petitioner not named in FIR, my lord, subsequently charge sheet submitted against the petitioners and others. They allege that the petitioners and others they are taking care of the cannabis plant, my lord.
ଏଥିରେ ବି same day disposal ପାଇଁ ଥିଲା.
Same disposal ହେଇଥିଲା. Co-accused also bail agent.
Modification petition ଟା file କରିଦଉନାହାନ୍ତି.
Both the cases, lordship, Odisha Oakland file puno say that case. I have not filed. Other counsel have filed.
So
case of 2019 will not due to COVID-19. He could not.
Dispose of matter you can file.
In this case, surrender, my lord.
No.
Surrender and taken in consideration.
No. Already an order has been passed. I will not pass another order. Already there is something by जो order टा pass होची ना गोटे केमते आपन को order pass करी. से I just taken आपन का आगे हैला ना नहीं order टा. I modified it. I granted time. Same since those honorable judges are no longer there, I can pass that order. You file an application for modification in that case.
Modification in that case will not. I have to
you file. You not press this application. That's all. I will modify it. I'll grant you time to appear in terms of that order. And taking note of the fact that the co-accused persons have also been released on bail.
Released on bail, my lord. Yes.
That parity I will direct. So you file an application for modification. Yes. This is matter next week.
Item 52.
Next week we will file kar do.
Yes, my lord.
Item 52. Offense under section 341, 323, 324, 325, 326, 307, 302, 427, 506, 34, and 25 Arms Act. Meantime, 1 year already passed, charge sheet has been already filed, my lord. And he accused already released on bail. This petitioner is a co-accused, my lord. Actually, my fault is I purchased some land, some piece of land from the deceased uncle. This is the only my fault, my lord. That is no direct allegation, my lord. ମୁଁ ଗୋଟେ 25 ଡିସିମିଲ ଗୋଟେ ଜାଗାରେ କିଣିଛି.
फिर तो नहीं खाली केस डायरी भी obtained for perusal of the court. Is this matter the piece of paper? 28th September. No course of action till then.
So item no 21.
Yes. 21 million. That matter. I'm appointing number 6 million.
That matter, who matter?
My lord, your lordship was first called out, but petitioner is absent. Asylum ki kusi.
None appears.
Item 52 certified
Urgent copy of the order begun.
Okay.
Item 21, none appears on repeated calls. Since this is a case of the year 2011, dismissed. Dismissed with the liberty ja tha. Yes. List matter କୁ
Item 45.
କାଲି ଅଛି କାଲି ଦବା ଏଇଟା ଗୋଟେ କମେଇଦବା।
मतलब item 45 ଟା ଆମେ ଏବେ ଆର୍ଜନ
ଆଇଟମ 45 ଆର୍ଜନ ହେଇଥିବ ତ ୱିକଲି ଲିଷ୍ଟ କାଲି ଦେଖିବା।